p.m. And we're in Department of Consumer Affairs in Sacramento, California. For this time, I'm going to hand it over to Christina to call roll.
Good morning. Christina Wong.
Here.
Betty Conley.
Here.
Jonathan Maddox.
Here.
For the record, Dr. Christine Whitlisbach is absent. We have a quorum.
Thank you very much. For this time, let's go ahead and do introduction. I'll start with Christy, if you don't mind.
Christy Berger, Regulatory Analyst for the Board.
Roseanne Helms, Legislative Analyst for the Board.
Jonathan Maddox, LMFT Board Member.
Betty Conley, LEP Member. Sabina Knight, Legal Counsel.
Christina Wong, LCSW Member.
Kim Manson, Executive Officer.
Thank you very much. So for the public, your introduction is voluntary, and if you choose to introduce yourself, please come up to the podium and set your name and your organization.
Jeffrey Liebert, AMFP.
Kenneth Edward, CalPIT.
Rebecca Gonzalez, NASW.
Janley Wong, National Association of Social Work.
Nabil El-Gaburi, California Association of Marriage and Family Therapists.
And Heidi Holmblad, California Association of School Psychologists.
Thank you very much. So it sounds like, the microphone is a little softer coming out, the amplifying. So when you talk, would you please just stand a little closer? And thank you very much for your introduction. So for now, I would like to welcome Mr. Jonathan Maddox, and he's the new member for the Policy and Advocacy Committee meeting. And I think Dr. Christine Whitlisbach, she's staying on, but she's not able to make it today. So welcome, Jonathan. Yes. So let's go ahead and move to item number 2, the approval of committee meetings minutes. And so the first one is the August 24th, 2018. Any comments? Yes.
We're going to table that. They're not fully prepared yet.
Yes, so that would be the April 21st, 2017. That would be the next one. Any comments? Board members? No?
I wasn't at the meeting.
Okay. You can still read it, yeah.
Oh, okay.
So any public comments, added changes? Looks good. So I need a motion. I will move. I will move to approve the meeting, the April 21st, 2017 minutes.
I'll second that.
Thank you very much. Any other discussion? So Christina, we're ready to vote?
Christina Wong.
Yes.
Betty Conley.
Yes.
Jonathan Maddox.
Yes.
Motion carries.
Thank you. So let's move on to item number 3 is the proposed legislation 2019 omnibus bill.
Yes.
And it's Christy. Oh, and it's Roseanne. Yes. So I'm thinking, Roseanne, maybe you can just, give us a, just describe, the changes all in once, and then we can discuss it one by one.
Sure,
Yeah.
sounds good. Yes, so it is that time of year again. Every year we look for technical or non-substantive changes for an omnibus bill to run beginning in January. And usually these are changes that are very minor, no opposition, and not big enough to run in their own bill. So I'm going to go through the items one by one. They can get a little tedious. So if you have any questions, be sure to ask. But for the first thing that we're proposing is in the LMFT statute, there are some required topics that the law and ethics coursework has to cover. And one of those topics for law and ethics coursework is differences in legal and ethical standards in different types of work settings. And in a recent committee meeting, when we were talking about license portability, it was suggested that the requirement really should say the application of legal and ethical standards in different types of work settings. Just to clarify that they're not necessarily different in different work settings, but the standards might be applied differently. So we're proposing that change. A corresponding change is being made to LMFT out-of-state requirements in the portability language that's already been approved by the board. And LPCC, the change is not necessary because the requirements are worded a little bit differently in their core content areas. So with that being said, moving on to item number 2, this was a change that was requested by our licensing unit. As we know, they have an ongoing issue of sometimes applicants, particularly in the LPCC arena, occasionally will submit an application where they're trying to piece together a 60-unit degree program, and it's not actually one program. It doesn't happen often, but it happens sometimes. And the law in the old LMFT degree program language it refers to the requirements of the degree. But the old LMFT requirements specifically state that the degree must be a single integrated program. It states that for the MFT degrees gained before 2012, but for nothing else, not the newer MFT degrees, not the LPCC degrees. It's implied that it has to be a single degree program, but they ask that we go back to specifically stating it in the law.
Can I ask a question, or do I wait to the end? How does that typically work?
Let's go ahead and finish
Okay.
presentation.
So for increased clarity, they have just requested that we refer to a single integrated degree program. Moving on to item number 3, where we talk about LMFT and LPCC statutes requiring an applicant to have coursework or practicum in assessment, diagnosis, and prognosis. At a previous Policy and Advocacy Committee meeting, a board member has suggested that replacing the term prognosis with the term treatment planning might actually be more accurate. So we're proposing to make that change in the relevant areas. Moving on to item 4, there are several areas of statute that reference the board's laws and regulations. And it would be more technically accurate to reference statutes and regulations. A statute is either a law written by Congress or a state legislature, whereas a regulation is written by a government agency. So when we talk about laws, that can refer to either statutes or regulations. So it would really be more effective in the law to say statutes and regulations instead of law and regulations. Okay, moving on to item number 5, pre-licensee service locations. Current law states that pre-licensees can only perform mental health services where their employer regularly conducts business and services. In the Exempt Setting Committee, we're talking about proposing language where the individual be permitted to perform services at the place where the work site permits business to be conducted. And the feeling is that better accounts for situations where an employer requires an associate to occasionally travel off-site, maybe meeting a client someplace like the patient's home or another third-party location that's not regular, but it's required for some reason and it's permissible. Moving on to item number 6. This is a request from our enforcement unit. We have a section in our laws that discusses parameters regarding the examination, taking the examination and getting results of the examination when an applicant has a pending complaint against them, or the board is in the process of conducting an investigation. So we're proposing three amendments to this language because it's a little bit out of date. First of all, we propose removing the 2016 effective dates because obviously that's already passed. The current language permits the board to withhold the results of an exam under certain conditions if the applicant is subject to a complaint or investigation, and we really can't do that anymore very feasibly. exams are all given electronically, and the individual gets the results when they're done taking the exam. So to say that we can withhold the results for some and not others is really not feasible. They're going to get the results. It's programmed that way. So we're proposing to remove that piece. But at the same time, the section also permits the board to deny admission to an exam or refuse to issue a license if an accusation or a statement of issues has been filed against the applicant. The board's enforcement unit also sees cases where somebody is applying to take an exam and the enforcement unit is issuing a petition to revoke probation at the same time. Maybe they violated their probation, and so the board is pursuing revoking it. So the enforcement unit would like the ability to also deny admission to an exam in those cases as well. And so that has been proposed in the language. Moving on to item 7, the next couple items are kind of some updates to some older language that over time needs a little bit of updating. For the MFT aging and long-term care requirement, there's a section in the law that talks about applicants needing to have this coursework if they began. It's actually for licensees needing to have this coursework if they began graduate study prior to January 1, 2004. And it specifies that licensees who began graduate study before that time have to complete a 3-hour aging and long-term care CE course. The provision is no longer needed and can safely be deleted now. Any applicant currently applying for a new license must either meet the requirements of 4980.36 or 4980.37, depending on when they got their degree. Both of the requirements include the aging and long-term care coursework as a requirement. Out-of-state applicants also have to meet these provisions. That's in 4980.81. And anybody with a license now that has a license, even if their degree was before 2004, is going to will have already taken the aging and long-term care requirement. So there's just no need for that provision anymore. It can go away. Kind of along the same lines, but a little bit more complex, is item number 8, the spousal and partner abuse coursework requirement. Now, this gets a little more complicated. There's a couple of sections in LMFT and LCSW law that require applicants for licensure to complete 7 hours of CE coursework in spousal and partner abuse if their degree was begun prior to January 1, 2004. And then there's also mention elsewhere in law that that applicants for licensure have to have the spousal and partner abuse, even though amount's not required. So basically, we have a requirement saying to get a license, you have to have spousal and partner abuse. But then once you have your license, if you have an older degree, you have to take CE your first renewal period until it equals 7 hours. So it kind of makes more sense, we thought, to put that requirement at the beginning. Pre-licensure all in one place. It would be 7 hours pre-licensure rather than pre-licensure and then when you renew it has to be 7 hours. We're finding that it's really difficult with the CE requirements when you're not requiring something up front. A lot of people will fail CE audits because they don't remember to take that specific coursework in the first renewal cycle. So it's really better to just have them take it up front so that it doesn't get forgotten later and then they become subject to a citation. So we're proposing to streamline that requirement so it's all the 7 hours pre-licensure. And then finally, in terms of item number 9, petitioning for a reinstatement of a registration. There's kind of a technical issue in this section that needs to be updated. The section discusses timeframes for disciplined licenses and registrants to petition to modify for disciplinary action, including when they can petition for a reinstatement or revoked license or registration. However, the law actually prohibits a registration for being renewed or reinstated beyond 6 years from the last day it was issued, even if it's been revoked. So there's a situation that happens sometimes where we're saying somebody can petition, but if the registration is actually more than 6 years old at that point, the law doesn't allow us to reinstate it. So it's a pretty easy fix. We would just like to say that instead of, in that particular case, the person petitioning, because they technically can't, that they would need to apply for a subsequent registration number. So,
Thank you, Roseanne.
you're welcome.
So, so Jonathan, you had a question, right? You have had?
I
Yeah.
have a couple of questions.
Okay.
So
Go
as
ahead.
it relates to Amendment 2, I wasn't quite clear of what they were actually requiring. Are they saying that a student must attend one school and graduate from there and get all their coursework done in that one program, like, for example, at Cal State Fullerton, and they can't transfer? Or are they saying you can't piecemeal, like take a couple of LPCC classes, an MSW class, and then 4 MFT classes and get your degree and be able to apply? I wasn't clear.
It's the second. Somebody could transfer, they're going to ultimately get their qualifying degree if they transfer to Fullerton, it would be to Fullerton even if they had started and done a year at a
East Bay
different,
or-
yeah.
okay.
But we're saying you can't, take 5 courses at this school and another 5 courses at this school and then submit all of those transcripts and have it equal a master's degree. There has to be a qualifying degree program. There is some coursework that the law allows to be made up outside of the degree, and that would still be allowed, but we just want to emphasize that you have to have a qualifying degree program.
Okay, thank you.
We're not, it's what the end result is with the degree. So it's just, you can't piecemeal it after the degree has been issued.
Okay.
Yeah.
Thank you.
And the law already actually allows that. It refers to the degree program singular, but it's a little bit easier for licensing to explain that to people if it says it a little bit more clearly.
Thank you. And then my other question was under number 6. And this is just a question I'm wondering. So how does the role of being presumed innocent impact our ability to deny someone admission to a test? Just because someone is being investigated for something, does it mean that they're guilty? And so if we are saying that we could potentially bar them from taking their test, we are actually punishing them or giving a consequence for something that they haven't necessarily been found guilty of. So I'm just wondering legally, are there any sort of hurdles that we have to sort of manage or be aware of to keep us from doing something like that?
We're going to let them go through the test. We're going to let them get their results. And then at the point, after that, then they have to submit an application for initial licensure. At that point, we would hold off until the board is certain that the public protection mandate is satisfied. So that's what we're doing. We're letting them through the exam process now. Holding the results is not happening because the automated process. So legally, and Sabina can concur or disagree, but legally I think we're fine.
Okay. And the reason why I asked that is because actually in the recommendation, it says add a provision allowing the board to deny exam admission. And so I don't know if what you said addresses that statement, or does that statement need to be more broadly defined so that it says something along the lines of if someone is actually found guilty and placed on probation, we could do that? I mean, how do we have to address that? Because that clearly says the board can deny exam admission, and it doesn't clarify the criteria for that.
Roseanne, do you remember what they were concerned about in terms of the exam?
Right. So on if you want to look at page 41, under 4980.50, it's subsection E. And so the current law there in its current authority allows us to deny an applicant who has previously failed the exam, one of the exams, permission to retake. And then we can also prohibit admission under certain circumstances, and that's when there's a accusation, a statement of issues, and then enforcement is asking for also it to be when a petition to revoke probation has been filed. So that's already existing authority. Whether or not we use it, I don't know.
Correct.
But it's only under specific circumstances, and then the way that I read it, when they've already had a chance to take the exam, then they can't keep taking it, is the way I read that.
I agree. And the fact that it says may is permissive, I don't know, I'm not aware of any instance where we have denied someone the opportunity to take the exam. I am aware of when they, if they're successful and they submit the application for initial licensure, we've denied that because of a pending investigation. So, I don't know that that answers your concerns, though. It does? Okay.
It helps.
So it seems to me that it's clarifying the timeline, because the authority is already there. So it's, it's putting, that a clearer parameter, when you can, deny the examination and that kind of stuff. It's a matter of clarification.
It's basically doing two things. It's saying we're not going to delay informing anybody of their results no matter what. But then it's saying that we can deny admission to an exam or certain things, in addition to the accusation or statement of issues, also when we're in the process of revoking probation.
Thank you.
Yeah, okay. Any other discussion in regards of the omnibus bill, the changes? Okay, Kenneth.
Kenneth, California Association of LPCCs. On number 5, I had a question recently if that includes teletherapy for pre-licensees. Is there any language around that? Teletherapy.
Telehealth, yeah.
I believe it would, if it's something that their employer regularly allows, it would include teletherapy. And we have established in previous law clarifications in past years, I believe there's one coming this year, that pre-licensees can do telehealth, can perform telehealth. So I think that would be included. Sabina, do you agree? Yeah, if it's something the employer regularly permits, then it's acceptable.
Would it be, so I guess my question, a follow-up question to that be, would it be beneficial to suggest that they add sort of a sentence that actually says any sort of technological device, any technological processes that is approved by the agency? Because I guess travel would, in my mind, mean getting in my car, getting on a bus, walking to a physical location versus some sort of technological process that would mediate mental health care. I mean, I'm wondering, is that clarification necessary?
I don't think so if it's where the employer regularly conducts business and services. I don't know, offhand, where else telehealth is addressed in your specifics practice act, but we have the BMP code.
It's addressed in 2290.5, and then the actual language that we're talking about is on page 40. It's 4980.43.4a, so about 3/4 of the way down the page. We're basically striking right where they regularly conduct business and services, and basically saying where they permit business to be conducted. So I don't think that, my opinion, it's not appropriate to get into a conversation about telehealth there because it's already addressed elsewhere. The only time we would probably do that was unless we wanted to specifically exclude telehealth, but we don't.
Okay.
So I don't think that that's needed.
And just a reminder, omnibus bill, it's really about, changing the language, not the concept or the content of the, of the law. So a lot of times it's about, clarifying, deleting obsolete languages and stuff like that. So that's just a little reminder. Kenneth?
Kenneth Edwards, once again, California Association of LPCC. I think I wanted more specific around where the pre-licensee was performing the telehealth. So are they in the office where they would normally do it? Or would they be able to do that, say, from their home as a pre-licensee? I think that was kind of more specific.
Okay. I think that might be good. I don't know that it would be appropriate for the Omni bill.
Okay.
We are going to have a telehealth conference or telehealth committee after the first of the year, and really looking at the whole concept of teletherapy holistically, and I think that's probably a better spot to define that. Because what my reading of this is, if the employer is permitting that business to be conducted, that's sort of broad. And so if you're permitting that teletherapy to occur in the office setting, perfect. And I can't imagine any employer right now that would let their pre-licensee trainee conduct teletherapy from their home without any kind of observation. So, but yeah, we'll hold that good thought.
Sounds good. Hold on to it.
Yes.
Would be a good future agenda item, yeah. Okay, any other comments? So the rest of the languages looks good, clear? Okay, so now, Sabina, how should we make a vote? So it's just accepted? Would that work for you? Just entire thing? Okay, so I'll, any board members want to have a motion?
That all of the omnibus bill changes be accepted as written.
Yeah, and we're going to recommend it to the full board.
Under the recommendation on the memo, there is a sentence there that you can utilize
On
as
what
part of your
page?
motion.
What page?
Also, we prefer to not use the word omnibus bill when we're doing the motion, is just because there is the possibility that some of this may not be able to run in an omni bill. They might say it's too substantive, and then we have the option, if the board hasn't directed us to put it in the omni bill, then we can put it in a different bill maybe.
So we've done part of it.
Right, so you're going to.
So I put forth a motion that we direct staff to make any discussed changes and any non-substantial changes and submit to the board for consideration as a legislative proposal.
I'll second that. Any other discussion? Okay, so we're ready for vote.
Okay. Christina Wong?
Yes.
Betty Conley?
Yes.
Jonathan Maddox?
Yes.
Motion carries.
Thank you very much. So the next discussion item is in regarding licensed educational psychologist as supervisor of associates in certain setting. And I believe it's Roseanne again.
Yes. So at our last Policy and Advocacy Committee meeting, we had a presentation from the California Association of School Psychologists, or CASP, and they indicated that they're interested in pursuing a legislative proposal that would allow licensed educational psychologists to act as supervisors of AMFTs, ASWs, and APCCs while they are providing educationally related clinical mental health services in educational settings. And in their presentation, CASP, and their presentation is actually attached as attachment A for review. They indicated that many school districts are actually using associates to provide what's called educationally related mental health services, or ERMS. And state law requires people that provide ERMS services to be supervised by someone with a pupil personnel services credential. And they noted that LEPs already have this, so instead of a school district having to hire other types of individuals to supervise, LEP is really a perfect candidate to supervise these individuals. So we had the discussion, and we heard what CASP had to say, and then the committee agreed that there was potentially value in allowing LEPs to supervise associates in these certain settings, as long as clinical services were being performed, and perhaps the amount of supervised experience hours allowed to count toward licensure should be limited. One stakeholder did raise a concern about whether allowing LEPs as supervisors would affect license portability to other states. And so the committee at that time directed staff to look into those concerns a little bit further and report back. So we took a look at a couple of things, just really quick, in terms of the length of the school year, just to kind of get an idea of how long a year, how many hours a year might be, although CASP did mention, and it's worth discussing, that it doesn't necessarily have to be, the supervision wouldn't necessarily have to be in a school setting, so that kind of makes this argument moot. But according to the education code, a school year is required to be at least 175 days. So if, let's say, an associate had a full-time one-year placement in a school setting, assuming that all of the hours were clinical, which is a very big assumption, I think, 175 days of school and 8 hours a day would be 1,400 hours. So that's kind of what you're looking at for a school year. And like I said, that estimate might be very high. I focus more on the license portability issue to other states because that kind of raised some interesting questions. So I tried to contact a number of states. Some I heard back from, some I didn't hear back from, but was able to kind of go into the laws and try to get some answers. And overall, it looks like in most, but not all cases, it would not necessarily, the other states might accept the hours. We found, for example, in the state of Florida, and this is kind of typical of what we found, that there's two methods to apply for licensure. There's licensure by examination, which is the regular process sort of that we have, and then by endorsement, which is kind of similar to what we're looking at with the Portability Committee. They indicated that if it was by endorsement, they had to be licensed in their state for 3 of the past 5 years, and then they would allow supervision by LEPs. They're not going to look at the specific requirements of each supervisor if the other state accepted them. They indicated that if it was by exam, though, the other route that doesn't require licensure, it has to be, the supervisor has to be equivalent to a qualified supervisor as determined by their board. And they don't list LEPs as an equivalent supervisor. A lot of states don't have LEPs. It looks like Massachusetts does, maybe a couple of other states, but it's areas of focus.
Thanks, Roseanne. So now we're going to open it up for discussion for the board members. Betty, you're waiting.
I see this as a really, really critical issue in schools. We have a lot of licensees and associates providing services to students in schools. And it is a very unique and specific form of practice that LEPs have the education, the background, the experience, the training to be able to provide the kind of supervision that is needed. And oftentimes, licensees who have not practiced in schools under the requirements of ERMS are coming in at the counseling with a very different approach. And our focus in schools is specifically educationally related. So classroom outcomes, understanding disabilities, special education laws and parameters, and those are all areas of expertise for LEPs, because that is really our focus. So I heartily encourage us to consider how we could be supportive in this.
Betty, with respect to capping the hours, do you feel that's appropriate?
I do.
Okay.
I do, because ERMS is, as I said, very unique. And when you are issuing a license, you're issuing a license for someone to be able to conduct therapy in a wide range, many different areas. And those areas are not all going to be covered in ERMS-based therapy. So it is a unique practice, just as some of the other areas of practice are unique. We wouldn't want someone to spend their whole time working only with geriatric, or only with, we really encourage our licensees to get a broad base of experience. And I think that is what supports the credibility of our licenses. But I think that allowing an LEP to supervise the ERM-specific piece of it would be really valuable.
So what could we expect? Roseanne calculated 8 hours, 175 days.
And again, if you're talking about student contact time, it wouldn't be 8 hours. It would be more like 6 hours.
Okay, that's what I was wondering.
But if you're including supervision, consulting, review of records, all of that, then it could easily be 8 hours.
Okay. And if we were to cap it, if the recommendation was to cap, do you think is a reasonable or appropriate amount?
Well, the school year, typically we have 180 days of student contact time. That is more typical.
Okay.
And I would definitely like to see us go to that 180 days. Now, if we're going to really look at the 8-hour days with the other components, because there are additional components, there's meetings, there's all kinds of things that extend beyond the 6-hour student contact time. I think an 8-hour day is reasonable with 180 to 183 days would be very reasonable. And I think, considering the number of hours that we ask for, that still allows for a substantial number of hours to be gained in other scope, in a different scope of practice.
Okay, so you're thinking like if we did the 180 times 8, then the cap would be 1440?
Well, I would round it up, but I think probably a little bit, but,
Okay.
I'd like to hear what CASP has to say too.
And I think Christie's been waiting.
I just have one other possible way to think of it. So an applicant for licensure has to have 104 weeks of supervision. So that's sort of goes hand in hand with the number of hours. And so you might think of it in terms of the weeks of supervision. So that might be a simpler way. We have something similar in LCSW law. All applicants have to have 13 weeks under an LCSW. So that's just another way to consider doing this.
Right. And Jonathan?
So I would agree with that this is a complicated issue and one that needs to be looked at, but I would not support LEP supervising MSW, PCC, or MFT associates because the scope of practice is drastically different. As you all know, I work in a very large public mental health system here in the Bay Area. And I know that most school districts that actually provide educationally related mental health services contract with the county and or community-based organizations to provide those services in the school district setting. And so when those students actually come in and provide when those associates actually come in and provide those services, they have clinical supervisors that are connected to their agencies that provide the supervision that those students need so that they can function within the scope of their practice. I think one of the things we have to remember is that services are not necessarily for the practitioner, the associate, to become competent in educational sort of learning processes per se. It's about their ability to address mental health disabilities that are impacting a student's ability to make use of the educational setting. So there's a different sort of scope of supervision that needs to occur so that this clinician can become competent in being able to help students who are depressed, anxious, psychotic, have behavioral disorders, manage and regulate those so that they can make use of the educational setting. They don't necessarily need to know all the ins and outs of sort of the learning process and the learning disabilities per se. My other concern would be, I'm wondering sort of if we're allowing this to happen, what impact is this going to have long-term in terms of them understanding and functioning in their scope of practice and their preparation for licensure. It gets very confusing if I don't have a clinical supervisor from my discipline that's helping me stay in my lane, function in my scope of practice that will lead me to be able to successfully navigate my testing and my licensing process. So that's a concern. One thought, because I do think that there is tremendous benefit to having broad-based sort of multidisciplinary work, is how we could look at wording something where LEPs provide consultation, which is a distinctively different process to support the needs of associates that are working in school district settings. I don't think that we could call it we could call it supervision, because supervision is something distinctively different. But I'm wondering, is there a way that LEPs could be on site to provide consultation as needed to associates who are struggling with a particular area or a particular concern related maybe to the educational setting? But I do think that associates from particular disciplines need to be supervised for the totality of their hours by practitioners who are in their field, or psychologists or psychiatrists that have a mental health focus and can support them to sort of stay in their scope of practice. So I think that we need to sort of probably further discuss this, because this is not as easy of a concern to resolve and address.
You make some good points, Jonathan. The one about the community mental health contracting, I have been in a couple of meetings recently, and I think the schools are not getting those services anymore, that the contract is gone. And that is, but that's something that we could survey. I've got contacts at the county
Sure.
mental health, and we
Sure.
could bring that back. Because if that service is gone, then there's no ability to,
Sure.
this sort of would, this proposal would bridge that gap.
Sure.
So that's one thing that we could do. We could look
Sure.
at that. And then, other disciplines like LCSWs have the requirement, as Christy mentioned, the weeks of supervision as well as the hours under their specific license type. Then,
Sure.
that could be another idea to address some of your concerns. And something that Betty spoke to as well is broadening, making sure that they have a well-rounded experience, but it's focused in their lanes, as you
Sure.
say. So,
So I guess I would, so I think that's a very good point of sort of looking at what other counties are doing. I know specifically San Francisco has services that are provided by the county, so either county staff or community-based organizations that are in our system of care provide those on-site mental health services. So I know in San Francisco for sure that exists, but I would be curious to know what other
I would be too.
principalities are actually doing. And so I guess to address your second point, I would reiterate that I think maybe we should still not call it supervision. I think there's a way for LEPs to have an impact in the clinical development and professional development of associates, and it'd be called something else, consultation or something else, but it not be supervised hours, because I don't know of any other discipline that allows people to be supervised by personnel or professionals from other disciplines to inform sort of how they do their work. And I could be wrong, but that's my thought. Thank you.
So Jonathan, I share your concern about, how who are those associates, being employed, or deployed, to the school setting. I think, even in my county, we have our county staff, to provide the services, at the school setting, and we provide supervision. And so, so I think, that definitely, I think Kim can, certainly do a little bit more research. And yet I'm also thinking about, when we're talking about the quality of mental health services, what will be the advantage of having, an LEP to provide, who are the expert of doing assessments and, doing, the diagnosis, because, they have all these, really wonderful instruments. And then really be able to look at, the mental health in the hybrid, setting. So, so I'm actually thinking, I like the idea of having, different supervisors from different disciplines. I mean, from the LCSW, we allow, the LCSW can get license or the clinical hours, through the MFT, the LPCCs, and also the social workers. So, so that they get a very, very different perspective. And so I think, especially for those students who actually work in the setting, having that, a capped hours of, supervised experience by the LEP, I see the advantage of it. So, so maybe we can look at, also kind of, instead of the consultation, maybe the other way is to look at, what would be the reasonable cap, for the hours or the weeks, like the 13 weeks for LCSWs, or maybe, for the LEP, it will be, say, like, I'm just pull it out, like 4 weeks, that they can really learn, or maybe 8 weeks, they can really learn about, how, just, how the educational setting, the mental health and how it comes together. That's just my point. So,
Well,
Patty?
Just to wrap up, and I think we're probably going to agree to disagree on some of this, and that's why I would really like to see a really robust conversation, even at the full board level. But a couple of things. You brought up the fact that several of our licenses do allow for supervision across licenses, and I think that provides a really interesting and quality perspective. But what I wanted to talk about was the fact that many districts do in fact contract with counties to continue to provide that service. That's an option. Many districts use their LEPs to provide that service, and I think it's a misconception that LEPs and LEPs, school psychologists, are kit-carrying assessors, and that's all they do, because our role has broadened tremendously over the last, 20 years of practice, and specifically with ERMs coming into the schools, LEPs are one of the primary providers of that mental health service in the school setting. So I would certainly make an argument that they are capable of providing quality supervision. And then just in closing, I think one of the challenges that schools face when they look to hire LCSWs or social workers are people that are coming into schools to provide those services who actually lack a really good understanding of what ERMS is and what it is not. And there clearly is a different approach when you're working in a school than when you're working in a very therapeutic session. And so I just think that there's a huge quality to be gained by allowing some hours of supervision. And I absolutely am in support that would not be all of the hours, but a portion of the hours to be gained with LEP supervision. So.
Yeah, Jonathan?
So I am definitely in support of having a more robust conversation because I think it's something that we should look at. But I think, I guess, a final point that I'd like to make is that one of the things we need to keep in mind is that associates, whether they're at a school district site, in a private practice, in a community mental health setting, are required to maintain, in most cases, Medi-Cal billing standards and documentation. And so I'm wondering, how do we consider that need to assess, diagnose, and treatment plan for clients if they're not being supervised by someone who has expertise and experience in that area? So I think that's just another caveat for us to consider. They are in ERMS, they are on a school district site, but they still have to do Medi-Cal billing and have Medi-Cal appropriate documentation. So my question would be, how can that be supported in this process if we're going to, consider that?
So, so Betty, what you just talked about, it reminded me that, I was a school social worker, when I was in Hong Kong. And so I totally concur with you that, a lot of the, the social workers, when they get, to work in the educational setting, they're not fully prepared, a very different kind of the take, how you conduct, services. And I want to respond to Jonathan. I think the Medi-Cal billing standard is one set of the standards, and it's not the golden standard. So I think, we county, social workers or mental health provider, it's very easy to use that, pretty stringent, standard as if it's one of them. And so I think there are different settings, that will have a different level of, expectation, how the documentation is being done. And so I think the most important thing when we come back, to the discussion is how do we make sure that the supervision quality, is able to prepare this particular associates, be able to, when they get licensed, that they can, have the minimum competency, to move forward and then be able to provide the mental health services. So, so at this point, I'm really curious about, public, any comments since we want to have the more robust discussion. So, any of you, any feedback? Hi, Heidi.
Hi, can you hear me?
Yes.
Okay, Heidi, excuse me, Heidi Holmblad from the California Association of School Psychologists. I kind of don't know where to start here. There are several misconceptions here among the discussion. One main thing, I can address the Medi-Cal thing right away. That is changing very rapidly by next year at this time. You really want LEPs there supervising because they are going to be able to bill for Medi-Cal. So there's a number one right there. The other thing is that if we called them consultants, the reason why we want to do this, let me back up, is because right now these people, these associates have to be supervised by two different people. They have to be supervised by someone with a PPS credential, and if they are in the schools. So, and if they are doing ERMs. So what we are trying to do is reduce the number of supervisors that have to be dealing with them at the same time. That's why we thought LEPs would be best for this, because they are licensed. We know that school psychologists who don't have the license would not be eligible for this, just LEPs. Betty's right, that other licensees are able to supervise across the different licenses under California law. I think we need a good discussion about AB 114, which gave the schools ERMs, basically, and told them they had to provide it. Some of them do contract still with counties. That is actually in a minority. Very, very few do that because it's very hard to get the money back from the counties to do that. So at this moment, it won't be in the future. So we could go ahead and have a more robust discussion about this. I'd like to get our LEP expert on our board of directors involved. I'm just the executive director and being pulled in 9,000 different directions. So I don't know if we want to continue this to a different time. That's totally up to you folks, but we are more than willing to answer any questions you have.
We might have, we could do a full board presentation at the board meeting in November. I think that meeting's looking reasonably light. I only know of one other presentation, and then we're into standard reporting. So that meeting will be in Garden Grove.
Okay.
With that, and it's November 30th.
November 30th.
Yeah, so we can carve out some time, Heidi,
Okay.
for you. And I'll circle back with you to see if
Sure.
there's a preference for morning or afternoon.
Oh, sure. That'd be
Okay.
great. Okay.
Yeah.
Great.
And there'd be a way to ensure that representatives from CAMP and NASW and other ones
Oh,
were there to
Are you guys
sort of
coming on November 30th?
have a similar conversation.
Yeah,
you are.
absolutely,
Sure.
absolutely. Yeah.
So Heidi, maybe even, Jonathan, brought up some really good points. And if, we're planning to have another presentation for you, maybe really to address, those specifically, about, the contract, when you talk about AB, 104 and go, what is that?
114.
114, so, so I think, those pertinent, the trend of the earned services, or even like do a little bit, data about, the kind of like, the number of the, associates, or the licensees, working in the school setting. I think those are all good information, maybe, specific, be a little bit more specific. And I think that might also, resolve, some of the questions that the board members might have.
Sure, yeah. We would also like to talk to some of the agencies such as Seneca, Lincoln, other ones like that, and they will probably give us a good idea of not only the numbers that they have working, but the importance of having an LEP there.
Sure. And I guess I'd like to add, along with that, I'm aware that there are a lot of school districts that have MFTs, LCSWs, LPCCs with the credential who are resident on campus actually doing the work. So it'd be interesting to know sort of what that looks like across the state, if that's data that can be found, because LEPs aren't the only behavioral health providers that are actually on site, because there are a lot of schools that hire LCSWs, as long as they have the PPC. So that'd be helpful
Right,
to
as
know
long as they
too.
have the credential.
Exactly.
Right. Okay. All right.
Thank you so much. Any other public comments? No? Okay, so we're watching, right? We'll see how the trend is going to go. So Heidi, maybe really, present a little bit more information would be really helpful. So where should we go from here? I think we have a good discussion, and we will just table it, for the next board meeting, and no action needed.
Well,
Okay.
you're not making a recommendation, so we'll just move it forward to
Yeah.
the November
Right, we'll
for
just.
full board.
Right, okay. Sounds very good. Thank you so much. And I hope, Jonathan, this is robust enough for you. Yes, wonderful. So, okay, so let's move on, or should we need to take a break, since we, it's about 10:28.
For a break.
Let's take a quick break, okay? So the time now is 10:28, and let's come back 10:40. Thank you. Welcome back to the BBS Policy and Advocacy Committee meeting. The time is 10:50, and let's restart the meeting. And the next discussion items is the registrant employment by temporary staffing agencies, and that's Christy.
Yes, thank you.
Thanks.
So the Exempt Setting Committee discussed at length some of the issues about registrants gaining hours of experience while being placed at a setting by a temporary employment or staffing agency. Staff is starting to see this a lot with registrants being placed at the Veterans Administration, so sometimes it's to address shortages in staffing for mental health providers. The current law for the three professions does not address a temporary agency's involvement in placing individuals gaining experience, and certain provisions of existing law are a poor fit for this situation, especially when the temp agency is considered the employer. So the Exempt Setting Committee, we've been working on some regulatory language to address these issues, and we've gotten a great deal of feedback from stakeholders. One thing I want to kind of clarify is we originally started talking about this as with the temp agency as the employer, but it came to our awareness that they are not always considered the employer, but it is typically the case where they are the employer. So, but we've removed any of that type of wording from the language, and it still works. It still addresses the issues. So let me get into what the current law is and how we're proposing to modify that. So right now, a trainee or associate is only allowed to perform services at the places permitted by the employer, something we talked about earlier. If the temp agency is the supervisee's employer, they should not be the one saying where they can perform services. It should be the contracting agency, because they're the ones responsible for the clinical services. So the proposed language specifies that the contracting agency shall determine where the supervisee can perform services. There's another law that requires a written oversight agreement when the supervisor and supervisee have different employers. The agreement is signed by the supervisee's employer and his or her supervisor, and the purpose of this oversight agreement is to clarify the supervisory responsibilities and to make sure the supervisor has access to client records. And so there's really, so basically when the supervisee has a different employer than the supervisor, we're making sure that that supervision can still be effective. So there's two issues there. The one is that the written agreement should really be between the contracting agency and the supervisor, as opposed to the temp agency and the supervisor. So we would make that change, and then it would also clarify that a written agreement is not required when that supervisor is an employee of the contracting agency, regardless of who is the supervisee's employer. So in other words, the law reads, basically, if the supervisor is employed by the contracting agency, yet the supervisee has a different employer, and that's the temp agency, there's no written agreement required because that supervisor already has access to client records. They're already part of the system where the individual is being placed. So that, oh, and there's one last thing, is temporary agencies, they have this tendency to issue a 1099 and consider the employee an independent contractor. Our law already requires an individual to be a W-2 employee or a volunteer, but we just wanted to add some clarifying language that a temp agency may not issue a 1099. They have to be a W-2 employee or a volunteer. So the proposed language is provided in attachment B.
Thank you so much, Christy. And this is all the hard work of the Exempt Setting Committee and coming down to, this set of languages. So any comments, board members? The language look good? Any recommendations, suggestion? Okay, it's really looking good. It's coming into really, really good shape. Yeah. Okay, so public comments? Looking good also? Wow, okay. Wow, okay, so in that sense, I just need to have a motion. So I'll make a motion to direct staff to make any discuss changes or and any non-substantive changes and recommend to the full board as a regulatory proposal.
Second?
Betty, second. And any other discussion? Okay, we're ready for vote.
Christina Wong,
Yes.
Betty Conley,
Yes.
Jonathan Maddox.
Yes.
Motion carries.
Thank you so much. And so we come into the report, and the first section is the legislative update, and that's where, wait,
One more.
oh, okay. Okay.
Yep.
So here's the next one. Oh, okay, so that would be the discussion and possible recommendations regarding practice setting definitions. And that's Christy again.
Thank you. So this item, bear with me here, it's a kind of a long one, and we'll go through it step by step. And it's all has to do with setting definitions for the most part, but we kind of delve into some other areas a little bit. And the issues are different with the different settings. So we worked extensively on developing these definitions, and right now we don't have any definition in current law for any type of setting, except for exempt settings have somewhat of a definition. And private practice in LCSW law has somewhat of a definition as well, but the other professions do not. So we feel that the setting definitions are really necessary in order to help clarify acceptable practicum settings for students and to implement efforts to protect consumers who are receiving psychotherapy from unlicensed and unregistered therapists in exempt settings. And it would also help clarify, there are a number of laws that reference private practice, and when you don't have a good definition, it's hard to know what falls under that and how to apply those. So we are going to start with exempt settings, and I just want to give a little bit of a background on these, and then we'll talk about the proposed language. Currently, as I mentioned, the only fully defined type of setting are those where the law specifies that they are exempt from BBS licensure requirements for their employees if the work is performed solely under the supervision of the employer. So unlicensed and unregistered individuals who are not pursuing a license can provide psychotherapy services in a nonprofit and charitable entity or a church or religious organization that meets certain federal requirements so that they're also considered a nonprofit and charitable. A school, whether it's public, private, or for-profit or a nonprofit, and government agencies. So the Exempt Setting Committee did a survey of individuals working in exempt settings, including supervisees, supervisors, executive directors. And so we got a good amount of data on them, and we considered that heavily as we were developing this information. And the committee members of the Exempt Setting Committee expressed some interest in addressing agencies where consumer protection might be lacking. And the problem is that some agencies do not fingerprint employees, some do not have a licensee who's supervising the unlicensed or unregistered staff, or they don't have a consumer complaint process. So what we are proposing is that unlicensed and unregistered therapists who are working in an exempt setting providing mental health services, they provide the consumer with a printed disclosure before they initiate any psychotherapy that contains information about how to file a complaint about the therapist with the agency, or it would also cover if it was an oversight agency of some sort. In addition, the committee developed language that would require all settings in which psychotherapy is performed, including private practices, to provide a written disclosure to consumers about that they can file a complaint with the board about a licensed or registered consumer. And this is a current requirement for other health professions, including psychologists, physicians, and dentists. I'm sure everybody's seen something like a sign in their doctor's office. So that proposed language is provided in attachment A. So I would like to stop there, and any discussion about this item, we can go forward with that.
Any discussion, board members? Looks good. Okay.
Just, and I know we talked about this extensively at the exempt committee. Um, Anything that we do that regulates exempt settings, even if it's as minor as a complaint process, is going to be a suggestion, right? I mean, we have no teeth to be able to enforce.
Well, for this particular section, yes, that's correct. We would consider it a best practice.
A best practice, a suggestion, and,
Mhm.
yeah.
Right.
So I guess it's just, I just think it's great. I support it. And I kind of take it with a grain of salt and.
Right, I mean, but you're right, but this is that, as Christy talked about, this is the setting where they're not pursuing licensure, it's just kind of here, FYI, here you go. We recommend it. When she gets to the other sections, it's a little
No,
different.
absolutely,
Yeah.
absolutely. It's clearly, I mean, it's an exempt, but I think by definition, it's an exempt setting.
Correct.
So we can recommend.
We can recommend and suggest and
And
encourage.
suggest, yes, and encourage.
I actually have a thought.
Yes.
I'm
Jonathan?
wondering, in addition to this, would it make sense to suggest that they give the recipients of services there a modified version of the therapy never includes sex sort of brochure? Not that
Oh.
they can report anyone to the board that's not pursuing licensure, but that they should be aware as a consumer that there are boundaries and sort of structures to this relationship and that certain lines shouldn't be crossed just to protect the consumer. And then I don't know if there is a sort of legal sort of pathway for someone who's not connected to a board, but they should really know that, certain things shouldn't be happening.
Correct. I think that would fall along in the same lines as this notice, wouldn't it, Sabina? Yeah,
Yeah.
so there's certainly no harm.
Right.
Well, I know one of the things that the committee had, and that I have on my list of many things to do, but is to develop some additional outreach materials for consumers and some that specifically address when your therapist is unlicensed or unregistered, what to look for. And so the other thing I wanted to kind of go back to is the way the law reads is that, so there might be teeth, I don't know, I think we need to explore this further, but the way the exempt setting law reads, if you look at attachment A, this chapter, meaning this licensure chapter, shall not apply to an employee or volunteer working in any of these settings if, so it does focus on the individual, so there might be, we can't go after the agency, but the individual is responsible.
And I'm also thinking that, you sometimes, if they're not the licensees, but the board may still, be able to do some citations or something like that, right? Or some other route that public approval, nothing.
We can't do anything if we don't have administrative authority. Where we would have authority is if it was determined it wasn't an exempt setting and they're providing psychotherapy services without a license, then we have some teeth.
Right.
But if you meet all this criteria here in the exempt setting, say for a school, or you're providing services in a church and you're not seeking licensure, there's not much we can do. I did have a follow-up question. Christy, on number 3, where it says the individual, if not licensed or registered with the board, and do we say, there was if there, I was wondering if the word should have been is. I don't know if that's a typo or it's just I'm misreading it. And I can be misreading it.
Good question. I think it should be is.
That was my thought.
I think it should be is, yeah. I'm not sure if it was a typo or not, but I think let's change it.
Okay. That was the only comment I had.
I'm not sure that we should change it.
Okay.
Because if they are licensed, if they are licensed with, or registered with the board, they're still in an exempt setting. But I think that it was if, because if they are licensed or registered with the board, then 4980.32 applies, which is down below. So I
Okay.
think it
So
actually
is-
is correct.
Okay, so it was me, which is fine.
Took me a minute, but yeah, I think it's okay.
Yeah.
Okay, sounds good. Sounds good. Good clarification. Any other public comments for the attachment A? Jan Lee?
I want to echo what one of the, Janley Wong, NASW, what one of the board members said about we're really not sure what their complaint process is really like. So that's of concern, probably not so much for public entities where the reporting authority eventually ends up with the elected officials in public entities. But in private nonprofit entities, it's a little less clear how they're responsible ultimately. So typically, if a complaint comes forth in a private nonprofit, it'll go through the supervisor, perhaps the clinical director if there is one, eventually to the executive director, and perhaps to the board of directors for a private nonprofit. Since it's unregulated, we don't really know how they handle those complaints. And the reason why I bring it up is over the years, I have received complaints about private nonprofits. And sometimes the private nonprofit follows, no offense here, but follows the advice of their attorney, which means they don't admit to anything. And they basically try to, handle it quietly, because lots of nonprofits are dependent on donations and contributions. So they don't want a scandal. They either try to settle it, or they terminate the employee, or they do something to not really address that issue. And to me, it is an important consumer protection issue. So I'm not sure what to do about it, but the language about having a complaint process and informing the employee, the consumer, is a good start. I just feel like maybe there should be something a little clearer about how that consumer complaint process might work. And if there's other avenues for people, which over the years I've had to advise consumers and practitioners that aside from the agency's own complaint process, there are actually other avenues that they could pursue. So I'm going to be sort of repeating these remarks when you get to the for-profit definition.
Thanks, Jan Lee. Okay, so Christy?
Kind of wondering if we can rope some of that into whatever we develop for our website. Not that the consumers would necessarily always know to look there, but I'm thinking there's some way to, if we're developing a pamphlet for consumers and your therapist is unlicensed or unregistered, if it's a nonprofit and you file a complaint and you don't get a response, you go to the board of directors. I don't even know if that's, I don't know, because it might go to a supervisor and go nowhere else, But even then, like Jan Lee was saying, it's the board of directors may not, I'm not sure there's any good answers. It's a tough one.
I think that's definitely a good avenue to, to educate the public. On the website, there is something for the consumers. So, so I think, our job for consumer protection, if we can identify, the ways that they could, make those complaints, whether it's to the BBS or whatever, I think it's also helpful, for the consumer not knowing what to do. So at least there is something to take it to the next step. Not necessarily, write them in the, in our law, but at least, if we have, some ways to, to provide those information to the consumer, I think that would probably, resolve some of the issues. The suggestions that Jenny made. And Jonathan, you have to say, you have something?
No, I agree 100%.
Yeah.
I agree.
Great. Wonderful. So, okay, so shall we move on to the next section?
Sure.
Yeah.
Okay, this is where it gets a little tedious, and we're going to talk about for-profit business entities. And there are a variety of different for-profit business types that can be set up for the purpose of providing mental health services. And despite our law referencing private practice quite a lot, again, LCSW statute is the only one that defines it, and it's very general. Our law does not contain definitions for any other type of for-profit entities except for a professional corporation. So I have provided in attachment B the LCSW private practice definition as well as the professional corporation definitions. So the types of for-profit business entities that are outside of a private practice or professional corporation, at least when I'm talking about private practice through here, we're going to kind of go with what is a general conception of a private practice. So it's a individual. It can also be a professional corporation who's sort of responsible for that practice and sets the conditions of exchange. And so we're going to talk about those entities that are not a private practice or a professional corporation. So you might have a company that's owned in full or in part by a non-licensee. You might have a partnership where there's multiple owners, and it could be non-licensees or a combination. You can have a general stock corporation. I've given a couple of examples. There's one called Telecare that's employee-owned, or HealthNet of California, which owns MHN, which is an employee assistance program. Then you also have public benefit corporations and flexible purpose corporations. Those are fairly new the last couple of years. So basically, if you have a general stock corporation, your primary responsibility is to your shareholders and making money. And these other types of corporations were carved out in law so that they don't have to always have that be their primary motivator. And not that every general stock corporation always does that. So like Telecare, when I looked into them, they do seem like they really are consumer focused. Because they're employee owned, they tend to be that way. So you can't generalize that everywhere, but it is something to keep in mind. The different types of for-profit companies in terms of what they provide, just a few examples might be a mental health clinic. It could be a substance abuse recovery program, or medical settings such as hospitals, medical groups, nursing homes, hospices, and dialysis clinics. And certain types of companies like this are regulated by the state, but the oversight really varies from lightly to heavily regulated. All of these settings that I just mentioned, the mental health clinics, substance abuse, medical settings, are either regulated by the State Department of Public Health or Department of Healthcare Services, with one exception, and that would be a non-residential substance abuse treatment program. They can operate without a state license, although some of them do obtain them. I did a little research about for-profits because there's a lot to learn in this area, a lot for me to learn in this area. So, and I talked about this already a little bit, is that the primary fiduciary responsibility of a for-profit is to their shareholders, not necessarily to the health of their patients. And so there is a potential for a conflict of interest. But in thinking about that, the profit potential in mental health really isn't the same as in the medical field, where you're dealing with new equipment and new drugs and things like that. The other thing is that any company that's providing these services, they're motivated to avoid liability by providing effective treatment. So you do have those kind of counterweights to that. So back on to the, did anybody have any questions about the for-profit types of agencies or any of that?
And that's attachment B, right?
That would be
The private practice definitions and.
Well, I didn't really go into, so attachment B just has the LCSW private practice definition and the existing law, so corporation definitions. I don't have an attachment that kind of goes into all these different other types of for-profits. But I do have attachments that talk about this next section. So I just wanted to make sure we're ready to move on. Okay. So on to the proposed definitions. So what we're proposing to do here is define private practice, and that definition is going to include professional corporations, which is already assumed under the law as a private practice. And then we'll separately define other for-profit settings. We, in the Exempt Setting Committee, we thought about including other for-profit settings within the private practice definition, but we decided to do it separately because then it would subject all of these types of companies to all the laws that pertain to private practices. So the proposed language is provided in attachment C. And so we go into private practice and we set forth, we really worked hard on this definition, not that there might be still some tweaking left to do to it. And we had some really great help from CAMPT, from David Jensen at CAMPT in working this out, because he's very familiar with the different business entity types. And then we have a very short definition of the other for-profit settings. And I'm going to focus on the other for-profit, and it's a for-profit business that provides mental health services and is owned in full or in part by one or more individuals who are not licensed mental health professionals. That's kind of the key there. So in creating these definitions, we're going to have this carve out. We really want to be very careful of the possible implications. I've got an attachment that we're going to go over in detail of all the laws that address or specifically mention a private practice. A lot of them place requirements on private practice that are not there in other settings, or there's some limitations. I was not able to identify in each case why certain laws only apply to private practices. I think we can just reasonably assume that there are some greater concerns about consumer protection in private practices because they lack any other layers of oversight, or they may lack that oversight. It might be one person, that's it. You've got your shingle out and it's just you. There might also be concerns about possible abuses of registrants. So we just have to, and we also have to be, in looking at for-profit settings about that profit motive that might have a negative impact. So let's go to attachment D right now. That's the one we really need to focus on. And again, bear with me because there's one thing I need to go back on, private practice definition, and I didn't cover it here in the memo, and I apologize for that. We developed a separate private practice. So I'm going back to attachment C on page 2 of attachment C. We developed a separate definition for the LEP profession because it's slightly different. We just had to do that slightly differently. So, and I think that was Betty, you had requested that. So just wanted to point that out. So let's move on to attachment D. And let's go one by one through here, through each of these laws, because we just really need to make sure what these possible implications are. And where I could find a reason for the law, I put it in here. Sometimes it's an assumption based on some information I was able to find that gave me some clues, but I'm not for sure, so.
And I'll just add one thing. The reason that we need to do this is because if we do put the definitions in law, we need to consider other areas of law that mention private practice but don't mention these other for-profit settings, and basically determine in each instance whether or not it's appropriate to include them too.
Yes, good point. So yeah, as we're looking at this, do we want to also apply this to a other type of for-profit setting other than a private practice or professional corporation? So again, professional corporations are always considered a private practice under the law, but a private practice may or may not be a professional corporation. So that's something else to keep in mind as we're going through here. And I know it's a lot to try to keep in mind, but I'll do my best to kind of keep us, and if anybody needs to stop somewhere along the way, I'm totally fine with that. So, because each of these laws are pretty different. A lot of them pertain to supervision and the licensing process, but some are, this first couple here are kind of separate. So number 1 on attachment D, military members who are issued a renewal waiver are prohibited from working in a private practice. So a renewal waiver basically is if you're active duty, you can apply to us to waive your renewal fee and your CE requirements while you're on active duty. That law that allows the waiver says that you cannot work in a private practice when you have the waiver. So the purpose of having this law is to support those individuals in military. We think that private practice was disallowed because you waive the CE requirements, and that maybe working in another setting is okay because there's a structure in place and some oversight. So if we were to change this, it would clarify, and you know, again, current law, we would probably say that right now this, this is where it gets really difficult for me, is that current law isn't clear, but if we were to nail this down, and I worked with our attorney on this, right now, the law says no private practice. So we go to that conception of private practice, and we don't include other for-profits. So right now, in other for-profit, this is allowed. So if you are on a renewal waiver, you can work in an other for-profit setting. But if we make this definition, it becomes even more abundantly clear that it's allowed. And do we think that that's okay? So that's kind of the thought process we need to go through as we go through here. So it's already allowed, since other for-profits are not mentioned in current law, and do we think that that's okay? So if you're on this waiver, and just, it's a little bit of background, I talked to our renewal staff, and we've only had 6 individuals that have held a renewal waiver since 2016. So it's not very commonly used. But the discussion is, should active duty military on a renewal waiver be allowed to work in an other for-profit setting? That is the question.
I would say yes. I mean, they're doing it now anyway, so I don't see a reason to prohibit them.
I don't see any reason, why not. So, I mean, I'm very just glad that, you point out, you're finding all these little places, so that we can make it consistent. So since now we separated those two, and if we, not allowed one or allow one, I think we just have to be, consistent across board.
Right.
Yeah.
All right. The second one is a private practice restriction on fictitious business names. So if you have a private practice under a fictitious business name, you can't use a name that's false, misleading, or deceptive, and you must inform clients of the name and license type of the practice owner. So obviously that's a consumer protection issue. So this would clarify that other for-profit companies are excluded from this law. And we couldn't find another California law that specifically prohibits a for-profit entity from using a name that's false or deceptive, or that requires informing clients of the actual name or license type of the owner. But there are some laws about a fictitious business name that they don't go quite this far. You have to use a name that's not, it doesn't say false or deceptive, but it can't be completely off base. So the question is, should other types of for-profit settings be subject to a fictitious business name law similar to what we have here? But again, if we were to implement that, there's no enforcement mechanism. So that's the other side of it.
I say yes, they should be consistent or not. I don't know. So Roseanne, what do you?
I think that if it's like a private practice or a corporation where it's specifically a group of licensed professionals working together, then they have some control over the name. But if it's just another company that happens to be a for-profit company, we don't really have any way to regulate what they're calling themselves. So I think it would be hard to put that requirement in and enforce it.
Can someone give me a concrete example? I mean, can we kind of ground, what are we saying? Like someone could potentially do what? I guess is what I'm.
You could have a fictitious business name that is, it can't be false or deceptive, but maybe, I'm sorry, it could maybe be a little bit misleading, but
So maybe someone starts a corporation and they call it the mental health medical group when there really are no doctors there, but they can do that and there's nothing we could do about it because that's
Right.
the name they chose, something like that?
Yes.
That would be a professional corporation, so it would apply, they couldn't use a fictitious business name. It would have to be something that's not like a professional corporation. It couldn't be a professional corporation or a private practice person to do it. It would have to be something like HealthNet would have to give themselves or one of their subsidiary companies like a false name somehow.
Trying to think what would be a misleading or a false name, so I can't even think of
My
one.
question is, are we paying attention to it now?
No.
No?
Are we getting complaints about it now? Not-
No.
So how big of an issue is it
No.
now?
I don't think it's-
Exactly.
Are we chasing
I,
this nice
I think in general with most of this, it's sort of a,
No.
yeah.
And I think it would lead to us getting questions about the business name and us not being able to answer whether or not it's misleading or not.
Right,
Yeah.
exactly. So I think if we're not paying attention to it now and we haven't had any complaints, I don't see a reason for us to pay attention
I
to
don't
it.
think so.
And I'm wondering if that were the case and consumers were harmed, there must be a mechanism for the consumers to go after that corporation
Yes.
on their own
Yes,
through
true.
legal matters or
Yes,
something else, correct?
I think it could be more of like a false advertising.
right.
And I think, there's all these, other business, more business-related, sort
Yeah.
of regulations that they can actually go back, to make complaints if that's really, it's
The
false
Better Business
advertising.
Bureau, the Better Business Bureau. something like
Exactly.
that.
Right, there's other recourse.
Or your county consumer
Yeah.
affairs business, yeah.
Right. So did it resolve the question?
Yes.
Yep.
Okay, good.
Okay,
So let's move on.
Okay, on to number 3, has to do with LEPs in private practice. So the law states that it's unprofessional conduct for an LEP when employed by another person or agency to encourage that agency's clientele to use his or her private practice for counseling without approval of the employing agency or administration. So basically, it's a conflict of interest issue intended to prevent an LEP from profiting off of the employer's clients. And the statute's use of the terms his or her private practice, it strongly implies an individual licensee in private practice. So I feel here that other for-profit companies are currently excluded from this law because it wouldn't be his or her, But I kind of wondered if there should be some sort of a definition that prohibits this action in any company that's wholly or partially owned by an LEP that offers those types of services that relate to the LEP scope of practice. So in other words, you're an LEP and you partially own this business that provides some sort of educational services. And is it okay for you to encourage your, clients at the school to come to your business? So I wanted to kind of have that discussion. And that would be, but that would be creating a new law.
Oh, no. No.
It's just not okay.
That, you cannot use, use your official position at the school and then, make it as an avenue for your own private corporation
And
or
that
private
needs to be
practice.
really, really clear in statute, regulation, whatever, because that is potentially a huge, huge conflict of interest. Yeah. And that is a unique, I think our license is unique to the susceptibility to that, in that most LEPs practice as school psychologists. And so they have an available pool. They have a pool. And so that has always been very, very clear, and part of the licensing training and everything else is that is not allowed ever. So that's.
Is that a similar issue that's addressed for, because I could see that translating well to someone who's licensed working in a school setting or setting like that, and they have a private practice. They terminate with the client and they say, hey, but I'm still, I'm available too. So I don't know if that exists for MFTs,
Not that I know.
or
I'm-
PCCs.
I haven't heard that.
Not as pronounced. It might be considered general unethical in the code of ethics, but LEPs is where it's traditionally been called out in the unprofessional conduct because it's more of a concern there.
Okay.
I was wondering, though, if instead of making a separate definition, if we could just amend the unprofessional conduct term, just to say maybe something like his or her private practice or place of employment,
I think that makes
rather
sense.
than creating a kind of a carve-out definition just for LEPs. Maybe instead of creating a separate like private practice definition, just saying in the unprofessional conduct provision where that that is, just saying that it's unprofessional conduct to do that in his or her private practice or place of employment. Rather than creating a whole separate carve-out just for LEP's a definition.
Yeah, so that brings up I agree with you, but that brings up a question for me. Would it be, I was thinking it's any business that's owned by an LEP, whether it's partially or fully owned, but it also be employed by? Employed, okay.
Yeah, because they are, if they have
A fiduciary stake in it.
right, a private practice on the side, then they could kind of funnel people over, and that, we want to make clear that that's not okay.
Okay, got it.
All right.
All right, great.
So, good direction. And number 4.
Number 4, and we're going to
5.
talk about 4 and 5 together, and I'm going to go back to the memo because this one's a little more of an extensive discussion. So we're going to talk about students and recent graduates pursuing licensure that are working in other for-profit settings. So right now, you cannot provide clinical services to the public unless you're registered or licensed with the appropriate state licensing board, unless there's a specific exemption in the law. And these 2 exemptions we're going to talk about, neither of which allow working in a private practice, but you have students pursuing a degree program, and then you have applicants who apply for associate registration within 90 days of graduation. So neither of those can work in a private practice, but they could work in any other setting. So students in a degree program, so for LCSW students, the law is less clear, but it implies no private practice. And I'm going to take this piece for LCSW students kind of aside in a little bit, because that law, as I looked at it, is not abundantly clear about private practice either, but we'll go back to that in a little bit. So one of the big reasons we needed to define private practice and for-profit separately is really the impetus for a lot of this is the schools really struggle with appropriate settings for their students. Is this for-profit setting acceptable? And part of their confusion has to do with sort of the history of the law. It used to be more specific. They used to specify settings, and then it went to become more general, and then that general definition was not very clear. So, but it does explicitly exclude private practices. And so we want to be sure, so right now they can be placed in other for-profit settings. We did a survey of practicum coordinators. Students in 42% of degree programs are currently being placed in for-profit settings, other than private practice, of course. We haven't heard particular problems with this, although the survey results indicated that substance abuse recovery programs are not always ideal because they can be limited in scope. Also note that the survey results indicated that 30% of schools don't have enough placement for their students. But we still have some question as to whether for-profit settings are truly appropriate for students, so we wanted to talk about that a little bit more. Because creating this definition makes it abundantly clear that it's okay, and but it would continue that restriction on private practice. So related to that is you have graduates who are pending an associate registration. So they clearly cannot work in a private practice. They can work in the other for-profit settings, and it's a similar concern, but actually a bigger concern here because the students have oversight of the school. These graduates pending registration have no oversight. They're not a board registrant yet. I mean, they are an applicant. You have to be an applicant to fall into this, and you have to be within 90 days. So, I mean, it's a little different from a student because it's when you're a student, you have a supervisor at the school, you have a practicum coordinator that is overseeing what you're doing. So really our discussion here is it okay for students to continue to be placed in other for-profit settings? There is, kind of the question that I think came to Roseanne in my mind is, why can't they be in a private practice yet other for-profit settings are okay? When those 2 types of settings do have some things in common. So why is it okay for one and not the other? We just want to be really careful with that. And then with the those pending associate registration, it's very similar. But if we decided to take away the other for-profit settings, especially from graduates. If we left it for students and took it away from graduates, you would have a gap where somebody might lose their job upon graduation, or they'd have to take a leave of absence. So it's a little bit sticky, but we just really wanted to make sure the discussion here, that we clearly understand what we're doing. Are there consumer protection issues? Are there other problems with this? So I'll leave it there.
It seems technical, right? But at the same time, it is a very important clarification about all these different categories. So, board members? Yeah.
It is a really tough one, and it took us a lot of wrapping our brains around it, too.
Yes, yes.
But just to clarify, within 90 days of licensure, that means that they've done all their requirements and have applied to be a registrant and just haven't gotten.
Graduation.
No, I think they've graduated already. I think they've already graduated.
Graduated.
Yeah, they've already graduated, and then they've applied to the board, but there's a turnaround time for
Correct.
issuing that registration. And so my understanding is that 90 days is to bridge the gap.
Correct.
So my question is, 90 days goes by, and then they can work in a private practice setting, right?
Yes, after they've been issued the registration.
Yeah.
Which might take longer than 90 days, depending if they have a deficiency in their file and they take their time clearing it up. We might process their application within a few weeks, and they take their time getting us, proof of completion of this course or whatever. So sometimes it can drag out, but
Is that the same but that would be the same for in other for-profit setting?
Yeah.
So those are basically, so I guess my prejudice would be that I'm just having a really hard time figuring out why it would be okay in one setting and not in another.
Right, I think it needs to be consistent.
I just do. I think it does. So, I mean, I'm not quite clear on why it's critical, the 90 days is critical, except that I understand that if they don't get their paperwork done, then they could be in a limbo where they've gone to work and accepted whatever and then have to stop.
Right, because typically what happens is that they're in a placement program, through the school, they're in a placement setting.
Yeah.
And they just continue on there because you've already got a trained individual. You're just waiting for the registration. This is hard to wrap our heads around. We struggle with it as well. But I think there are other for-profit settings, they're doing it now, right? And so I think that it's okay to continue to do that. That's generally not it's not an arena where we see any type of major complaints or a high number of complaints.
Jonathan.
So I just wanted, because I've realized I'm a very bottom line person. So it sounds like the bottom line question is, why should students not be able to do this, or graduates who don't have their registration not be able to do it? And then as soon as they get their registration, they are then eligible to do that.
Right.
That's the question.
No,
Okay.
it's a really, really good question. I was actually about to ask, what is really the rationale behind that, you're allowing, what will be the magic line difference, right? Yeah.
So I'm wondering if the magic line is because students and unregistered associates are not under the purview of BBS, if there are any problems or sort of unethical or illegal behavior, there is no entity that's able to initiate an enforcement action against them.
Correct.
So I'm wondering if we look at it from the perspective of, we're saying that once you become a registered associate, you are under the purview of BBS, and because these settings have the potential to be much less structured with much less oversight per se, even though they technically shouldn't, that BBS is saying we are going to wait until we're able to enforce actions and protect consumers until you can actually get in those settings. That's what I'm wondering, because as a student, it's left up to the school to address any sort of behaviors or law enforcement or something like that. So I'm wondering if that's the line that we should consider as an agency.
Yeah.
So in keeping with Jonathan's question, if we're saying that they have to have applied for registration, right? At the point that they have applied, doesn't that bring them under our jurisdiction?
Yes, but no. Because when we get the application, you have two actions. You can approve or disapprove the application. So, I mean, there's an action pending, but, so, I don't know.
So if we
Go
were to
ahead.
complaint, we couldn't do anything about it unless they were actually registered with us.
Correct. I mean, we can't, all we could do at that point is say, no, thank you. Right. So, I mean, if we're allowing them to, I don't know, this whole thing is,
Yeah, it's very confusing.
I have a question. If there was a complaint for something that occurred during that 90-day period, or where the person was a student and not registered with the BBS, can we investigate that? No?
no, not at all. It's because they're under the school's purview.
So, I'm just going back to my point. And I don't know what other people's thoughts were about my feedback, so I'm kind of hanging out here by myself. But since one of our roles as the board is consumer protection, it seems like, in my mind, it makes sense for us to say we need to protect consumers by saying you have to be registered to be in this setting, because then if there's a problem, we can actually move against it in a way that's meaningful to protect consumers, one, and then to rehabilitate students who just make mistakes because they're young in their career and they are learning and growing as clinicians. And so I think there's a dual benefit there for doing something like that.
I like that thought.
So let's give our brain a little break and
Yes.
hear what Jenny has to say.
Thank you. Jan Lee Wong, NASW. Somebody already mentioned it. As students, if they're still in the program, master's program, there is that oversight by the university. In social work, there's a field liaison, a professor, usually a professor, who is the direct contact if there's a problem with the student. Plus, there's other layers within the university, the department chair, the dean of students, et cetera. There is a structure in a university setting for students, enrolled students. So if you have a problem with students in a for-profit setting, usually you can work it out through the university structure. And there is a big penalty at the university level if there is a major, major problem. That student won't graduate. That's how universities work it. There is a big problem, as Jonathan has identified, when they graduate, they're no longer under the purview of the university, but they haven't quite reached your purview as a regulatory agency. So that is a problem. There's a little confusion here because we just did the 90-day thing, and so people are kind of thinking, well, we just did the 90-day thing. But the 90-day thing is really the idea of whether you will count their hours before they get their number, and they also have to pass a criminal background check. So you have some checks and balances in place there, but that doesn't mean you just automatically give them a registration number. They, of course, have to pass that initial screening for all registered applicants, registration applicants. So I think the student issue is probably, handled by the university thing, and, Mr. Maddox's discussion about that gap area, that problem area is a major problem. Now, often the other disciplines bring up the issue of a break in continuity of services. So they're a student, they're serving clients, but then when they graduate and they don't have the registration number, they can't serve clients anymore. So I think that rather than say, well, how do we accommodate this situation for potential registrants and licensees, which is really putting them above your main goal of consumer protection when you think about it. You're trying to accommodate these people. You put the onus back on them and you say, look, when you get into this as a student, if this is a situation where you're waiting to get a registration number after you graduate, do not take clients that rely on you in terms of continuity of service. And that is very doable because there's a screening process when agencies look at clients. When organizations look at clients, of course, they rank them by difficulty or intensity. And the more difficult, more challenging, more intense clients usually don't go to students. You know, they'll go to licensed people or registered people. So that's really the way to handle this, is to say, if you're a student, don't get any of those cases, and make sure who you're working for or volunteering with, they don't assign you any of those cases that are dependent on you, you know, once you graduate. Because this is not a how do we help these people highest priority for the BBS. Consumer protection is your highest priority.
Can I ask you a clarifying question? So thank you for your input, because that was very helpful. But I'm wondering, do you have a thought about, as a board, because I didn't hear you say, okay, I think they should be held, they shouldn't be in these settings until they're registered? Because I think, once again, part of what you're describing is we're putting the onus back on the students to not take cases. But as a board, in sort of looking at consumer protections, where is that, do you have an idea or a thought about that line? Is a line that the board say, okay, you can't be in this setting until you're registered? Or are you saying just put the onus back on the students and let them not take certain types of cases? Maybe you can clarify that, because I didn't hear the line.
I think the latter, but you have to realize also that you do have some leverage. And the leverage is back to the old 90-day period. If a graduate who registers with the board is interested in counting those hours, it has to be under a licensed supervisor. So there's your leverage. If there's a major problem with that graduate in that setting before they get their number, it should fall back on the supervisor. And it does. It does. Sometimes consumers will say, I talked to the supervisor and the supervisor didn't do anything. I had a complaint about this person and I didn't like their therapy and I thought they were doing a bad job. I complained to the supervisor and the supervisor didn't do anything. So that really is a complaint about the supervisor, who is regulated by the board.
So I'm guessing, I think it's good that we, that we have that bar for the private practice setting. I think that's perfectly appropriate. I don't know that, when I keep reading the definitions and looking back and forth on what we're doing, I mean, another for-profit setting it seems to be, for lack of, it could be, county mental health services or whatever. And that's another for-profit entity, so why would it not be appropriate for those folks to work in those settings? I just need clarity, because this thing makes my head spin.
So I actually, Kim, we're very much on the same, train of thought, because, I'm coming back, to look at, the type of the nonprofit settings. And oftentimes, apart from the for-profit part of it, they are a legitimate mental health services, like, hospital, especially if, let's say, like for the hospital. And so if we, I think we need to look at, it's like, whether those settings will be appropriate, for them to gain experience. And if so, then, then I see there's no reason why we should not be allowing them to continue for the for-profit part of it. So
I was just going to say, so I guess the thing that I've circled in the definition of the for-profit agencies is that their initial responsibility is not to the health of their patients, but to their shareholders. And I think there's an inherent conflict of interest there that I think could put a unregistered, very vulnerable, inexperienced mental health practitioner sort of at risk, because they're in an environment where they may be pushed or encouraged to move in directions that are not for their client's best interest, but for the interest of the corporation. And so I don't necessarily know what the answer is. I mean, and it could be minute, but I guess for me, that's one of the protections of having them be in those environments once they're registered, so that we could hold them accountable for decisions and things that occur while they're practicing.
Well, I think while we're struggling with this, so the other thought I'm having is that if we make the change and we bar them from working in an other for-profit setting, are we impacting the work, the services, the job, uh, well, not so much that, but it becomes a workload issue. I'm wondering if we're impacting the job market and we're putting people out of work inadvertently.
And also limiting the placement,
Well,
possibility too.
Yeah.
Yeah.
I mean, I think we all agree private practice. I think we're all on that
right.
page. It's this other definition that we're trying to create for other for-profit settings that we're struggling with. But
So it means that like, a license or a registrant, they cannot work in the hospital
right,
because of, that's the for-profit.
right.
Yeah.
And
So here's the thought, I mean,
yeah,
I know this gentleman has a comment. So I'm also as a director of training in San Francisco County, I'm also the internship coordinator. And so one of the industry best practices is that when a trainee gets a case, it's always communicated to the client that this is a student, they have a supervisor, and that this is time-limited treatment, much like the gentleman shared. You don't give them the
Yes.
high-intensity cases. And so in 100% of the cases, the expectation is not that that student is going to be hired by the agency and they're going to continue with that client. The expectation should be at the end of their traineeship, they terminate with their clients, and if they are hired, they would get a brand-new caseload. Now, in practice, I don't know how clearly that happens, but that's the expectation, because you can't really tell a client, this is a student, you'll be working together for 9 months, and then you will terminate because they will graduate, and then at the end of it say, no, we changed our mind. He's going to stay on board and be your therapist because we've hired them. I mean, that's not a best practice process. And so, on the other side of that coin.
Right, right. So that continuation of care is definitely, it's real. So welcome.
Thank you. Nabil Al-Ghawari with CAMFT. I do want to applaud the board for going into the issue of the definitions. This is a very confusing issue. At CAMFT, we get calls about this regularly. If this setting or that setting qualifies or for accruing hours. I think the issue of clarity is incredibly important. And actually, I would say it's clarity on a couple issues, the definitions, but then also the terminology we're using here. Once you earn your MFT degree, you're no longer a student. And so I think we've been using the word students to mean people who are graduates as well. In that the 90-day period, you're not a student. I think that is an important distinction, because when you're a student trainee, you are definitely under the university, as Jan Lee pointed out. But in those 90 days, you're not. So I think just being really clear about that. For CAMP's perspective, we would really like more clarity on what conditions. I don't know what it is yet, because I am still listening and wanting to learn, but that the trainee associates are pre-licensed individuals are working in settings and accruing hours that they believe will lead to licensure. And there are some settings where it's unclear. These substance abuse, unregistered substance abuse facilities, all these other types of, there's lots of different types of places where people are working, and they think they're getting hours that are going to count for licensure. And they need to know fairly at the beginning what those circumstances are. And so that's what I'm asking the board, is really to be crystal clear as much as you can, knowing that there's always going to be some exceptions, but as crystal clear as you can, so that informs the applicants that they know their rights and that they know that they're going to be getting hours that count. So I think that's important.
Thank you so much. Jan Lee?
I think it's really important to think about the processing period for registration applicants. So I'm not exactly sure what you guys look at, other than you do the criminal background check or you get the results from the criminal background check. But you might want to think about, and we're just brainstorming right now, the possibility that a 90-day person, applied for registration but not received their number, someone lodges a complaint against them in their workplace. And do you find out about that? If you don't find out about it, should you find out about it? It's kind of like when we hire people, sometimes we do reference checks to see if there's something in their background that we should be aware of. So that's something to think about. Maybe you just strictly go on the results of the criminal background check, which is just one side of it, because people sometimes have complaints lodged against them, and they may not be criminal. The other thing is, I think it's really, really important that this whole area of, and I'm going to use the example of hospitals, Christina brought that up. We do have a serious problem with hospitals. They routinely discharge mentally ill, homeless people without an aftercare plan. It's well known, the legislature's tried to set some policy in that area. That should be a big concern of this board, who was involved with that discharge. And if it was somebody, whether they haven't gotten their number yet or they have gotten their number yet, we should know about that, because that's totally unethical and unprofessional, and we know it. We know the horror stories that we read about in the newspaper. So for us to not even kind of consider that is like we're missing out. We're missing out on the goal of consumer protection. And yes, homeless people who are mentally ill are consumers.
So Jenny, sounds like, what you're saying is that, sometimes when the, registrant work in the for-profit setting because of the, fiduciary duties of, for the stakeholder, or AKA, they need to make money. Sometimes, even though they're placed or they work in that setting, they may not be getting the best practice, or the kind of like providing the standard of care.
Yeah, and you're absolutely right. And once again, I get calls. I don't know why people call me. I think maybe the board sometimes tells them to call
your
me.
number.
Yeah, exactly. But anyway, I do get calls of people working, social workers working in hospital and clinic settings, and really upset that they're being directed to discharge people. And they think it's inappropriate to discharge. But there's nothing they can do because they're being threatened with insubordination, discipline, perhaps even termination. And they're really, really upset about it. And I try to be supportive because that's wrong. It's just wrong. And I think you're right. The motive is profit. How do we get people out of the system, especially those who can't pay, who have no insurance or can't pay or whatever. They just find them difficult people, and they're pretty difficult people. Let's get them out of here. And, we treat their medical symptoms. That's what they do in the ER. That probably don't even provide any sort of psychological or mental health services, and just say, oh, we treated your medical situation, we're discharging you now.
So, so the problem about, I'm going back to the definition also. So if, so the types of the settings that is listed there, so they're definitely the for-profit companies, they're mental health clinic. And what Jenny's talk about are those who are not the mental health clinic, and then they have, whatever the nature of their services might precede, might come first, other than the providing the mental health service, which will be a big concern, in terms of the services, being provided. So I'm thinking about now, the for-profit company might be a very, very broad thing. So any possibility that we can actually say for-profit but mental health, that they're allowed. And then the other thing, I don't know, that, may.
You're talking about the 90-day applicants?
Well, the 90.
Or even, are you talking about students?
I'm talking about actually probably yeah, I know, it's such a tough one.
I feel like the 90-day ones are the bigger,
Yeah, the 90
concern.
days one, yeah.
But we could do some sort of a carve out. I don't know, necessarily change the definitions, but some sort of something that specifically addresses.
Yeah, I don't expect to change the definition, but I think the carved out probably would be, I don't know if, how helpful it is. Yeah.
Yeah, I'm not even sure what that looks like.
Yeah.
I mean, so let me, that's my, so another for-profit entity would be hospital, right?
That's one of them.
One of them.
Hospital.
And what other entities are we thinking about?
So
Or do we know?
if we go back to we've got, so mental health clinics, substance abuse recovery programs, then you've got like nursing homes, hospices, dialysis clinics, or the other medical groups.
Right.
Okay.
Yeah.
I don't know that we can even carve that out, though, because our licensing act basically says unless you're in an exempt setting, that the provisions of this chapter apply to you. So I would think that you have to have a license or a registration to work in those settings.
Well, but except for the law that deals with the 90-day and I worked this out with Sabina, it does allow for them to work in these other for-profits.
So,
It's the
a
way it's
mental health
written.
clinic is probably going to have a licensee on site because they're going to want to get supervised hours. A substance abuse recovery program may or may not have
Right.
one, but if they want hours, they're going to have oversight by a licensee. And a medical setting like a hospital or medical groups or nursing home, hospice, again, I think if they're working in that setting, they're going to have oversight. And my concern is if we exclude them from those settings, then we're impacting the workforce because they're already doing it.
It's definitely a consideration.
So that would be my concern. When I think that if they're going to be in a setting, they're going to have a licensed supervisor over them anyway, because they're going to want to count the hours. And what we're really concerned with is that whole singular private practice piece. I guess I'm just not seeing where there's a huge risk. But I almost, and maybe it's just because I don't understand this animal.
I know.
Okay, so, I mean, I keep going back for clarification, and I think we're all kind of struggling with that a little bit. So, is it fair to say that there is some confusion currently over whether other for-profits are included in the current law that says that an associate shall not be employed or volunteer in a private practice setting until he or she has been issued a registration? So is the confusion that I'm hearing from at least one of the speakers, is that applicants or registrants are not clear as to whether other for-profit entities are considered private practice? Is
Right.
that is that
Yes, that's the
confusion?
confusion out in the
That
world.
is the confusion.
Yes.
So our mission is either to say includes other for-profit, or specifically say does not include other for-profit. Am I clear in stating that?
Mhm.
Kind of, that's what we're trying to decide.
Yes.
Okay. So currently, the concern is that people may lose their jobs, that they're already working they've understood. So those people who interpret it to be okay to work in other for-profit, and that would be a question I have, is how many people are there that have interpreted that to be okay? We've accepted that. Up until now, we've historically accepted other for-profit. We have not carved it out.
I don't think we've carved it out. The question that we get is, okay, so the business looks like is structured this way. Is that private practice or not?
Or not.
So because it's either A or B right now, and I think we're doing A, B, and a subset of B. So the subset is really where we're struggling.
And the subset is specifically other for-profit.
Correct. And when I look at the settings that are identified, I see that as being structured in a manner to provide consumer protection anyway.
Right.
I think the only one that stands out to me is the substance
Right.
abuse programs, and especially because it's been making the news, there have been issues.
Right.
But
And-
most of them they are licensed. There's just,
It's a tough, yeah. Substance abuse is really a different animal because, they are the recovery program. And mental health is very, very I mean, depends on who you talk to. There's definitely a conversation going on, with, yeah.
But there's definitely, it's important that those services be integrated as well, so.
It should
it's
be.
like you
That's
don't
the,
wanna-
that's the trend. But,
Yeah.
Again, depends on who you're talking to. I think currently, we don't know, when a student, let's say, or graduate, work in the substance abuse recovery setting, whether they, how much, the emphasis really is on the mental health part of it. It might be a subset, it might be not. So, yeah.
So for my mind, I'm wondering, are we okay with students and pre-registrants working in a mental health clinic under supervision? Are we okay with that group working in a substance abuse recovery program? What if they have supervision by a licensee? I don't know how many work in there, but I mean, are we comfortable with them working in a hospital setting or in nursing homes providing therapy to those individuals, or dialysis clinics, hospice? Yeah, so I think rather than focus on yes or, I think we just need to boil the question down to that. Are we comfortable with them working in that setting?
With a licensed
What-
supervisor.
With a supervisor while they're awaiting licensure or under the auspice of the school?
It wouldn't be under the auspices of the school, though.
Yeah, so see, so this is all about those folks who've graduated and are waiting registration.
Yeah.
I think so, that's kind of where we're focusing, I
Yeah.
think.
Uh-huh,
I think that's very clear that they're no longer under the school.
right,
They've graduated.
right. Well, no, if we say that, if we go with the definition under Christie's chart, it said it would clarify that the trainees and students are permitted to work in those settings.
Well, I think that it sounds like we're clear that the trainees are under a higher level of supervision, so it really comes down to the 90-day rule.
90-day people,
And I think it's okay if we say that the trainees are okay, but the 90-day rule would read basically you can't work in a private practice or a other for-profit setting until, and I think that's, I don't think there's anything
I don't
wrong
think,
with that.
right.
I think that's okay if that's what the committee wants.
Right.
I'm good. This is such a big animal, it's so hard to tackle. But yeah, I think that's a balance, that's good.
Yeah. So, so you're really looking at that 3 months, the transition. So if the school, I mean, if honestly, if we set the rule and saying that, for those setting, that you cannot, for that 90 days, you cannot accumulate your hours. And I think, the graduate, they can take it into consideration while they, either they're finding jobs or not. And so I'm okay that, we say that, they don't accumulate hours, because they can make it up down the road. It's really not, I would like to have that clarity, what?
No, I'm waiting for you to finish.
Oh, yeah, sorry.
I'm not laughing at you, I'm just.
You agree, huh? Okay, so, so I would rather have that clarity, instead of just, being iffy. So I would say that, if we're just struggling, we'll just say, the current language is no, we cannot allow them. So I'm good with that.
And I would add that, and I think I initially said, I am good with that because it takes the consumer protection role out of the agency whose primary role is to their stakeholders and is financial. And it actually helps them to structure a training program that actually prioritizes the needs of the consumers. This is a student. You will work with them for 9 months. At 9 months, they will no longer be able to provide care to you. And so I think that's one of the sort of unintended benefits of actually looking at it the way we're describing it, that we're not letting them do that.
But I don't think it's okay to just leave it as it is. I think we have to clarify the language, because I've heard from stakeholders
Yes.
that have said, I don't understand whether this is or it isn't. And it sounds like, even looking at Kim, we have allowed other for-profit historically, currently. So if we're going to change that, it needs to be a very clear change.
Yeah.
And I would just want to make sure that the organizations are actually in support of that change. Is that going to really impact those folks that are working in those settings? Or is it, as Christina said, it's a matter of 3 months or even less than that? It could be 6 weeks. to get all their stuff together.
Yeah.
Yeah, the registration, even during the peak times, I mean, they're getting a registration within 60 days. If you, pardon? That's the highest it's ever been. Generally, in non-peak application times, you're looking at 30 days or less. So,
And the other thing you have to think too is they're getting right out of school, and a lot of them are still looking for jobs. So it's not, they're not even, I mean, possibly not even working, so. And, yeah.
And I also want to address, Jenny's concern about, the for-profit setting and the quality of the services. And I wonder whether, down the road, maybe something to consider, for the supervision part of it, because I think that is a really important thing. And I actually, have been getting, some, inquiry about, about the supervision, in the for-profit medical setting, because, when it brings up that the, the nature of the services, really when you look at the psychotherapy part of it, it's very, very limited. They do a lot of the case management, and yet, you have a supervisor actually just sign off all those hours as if they are getting, all these psychotherapy in, for example, a dialysis center. And you kind of wonder, wait a minute, how did it even happen? And so, so I think that is a really important point that, for consumer protection, how can we also tighten up that, in the for-profit setting, making sure that, those, the supervision are up to, our standard. But that might be, another topic, but I don't want to miss it. Yeah.
so we're going to have to go back and do the language now?
Yeah, we would have to go back and do language for this one and for that LEP.
Okay.
As well.
All righty. I guess that's what we'll do then.
Okay.
All right.
All right.
All right, so we have more.
We-
We solved one issue, but we have a couple more more than a couple, sorry.
Okay.
So all of these next ones apply to, in the licensing process, supervision, registration, and I think are definitely more straightforward. I'll just say that. So on to number 6 in the attachment. This has to do with supervisor employment and practice requirements in a private practice. So an associate working in a private practice has to be supervised by an individual who is employed by and practices at the same site as the associate's employer, or it has to be an individual who is an owner of the private practice. And then, if the site is a professional corporation, the supervisor must be employed full-time at the site and actively engaged in performing professional services at the site. So basically, you can't have an outside supervisor in a private practice or professional corporation. The assumption is it's to ensure adequate oversight, and other settings are okay because there's greater structure and oversight in the other settings. So by creating these definitions, it would clarify that supervisors in these other for-profits are not required to be employed by the associate's employer and are not required to practice at the same site as the associate's employer. In other words, you could have off-site supervision. So is that okay to continue?
Jonathan, yes? Okay. Any other comments? Okay, so there is enough oversight. Okay. Okay.
Okay, we'll move
So
on.
let's go to number 7.
Okay, this one has to do with associates and trainees and applicants who are reimbursed for expenses, so as under a 1099. And as we know, you can't be a 1099 employee, but sometimes when you're a volunteer, your employer will reimburse your expenses that you might have, mileage, things like that, and they'll issue a 1099 for those reimbursements. So sometimes we have people submit that 1099 and we go, oh, you weren't an employee, you were an independent contractor, we can't, allow those hours. But what they can do is say, no, this was for reimbursement, and show us that documentation. So it's not allowed in a private practice, and is this okay in an other for-profit setting? Would be the question. It is currently allowed, but is it okay to continue that practice? And
So this is, is this only for the reimbursement for traveling, not like through insurance reimbursement?
Right.
Nope.
Travel on. Just actually their expenses.
Yeah. So it would be, traveling, or maybe they go to a conference and they come back and do the reimbursement.
Right.
And it currently is yes. I would say yes.
So we're going to keep the same.
Keep the same. Okay. Any public comments? Okay.
Okay. the
Number
ne-
8.
Number 8 is the maximum number of supervisees in a private practice. So right now, you can only have 3 associates per supervisor. So in an other for-profit setting, you can have more than 3 associates per supervisor. So is that okay to continue?
So is there any change for the, for AB 93
Yeah,
for
that's
that?
all AB 93 changes are reflected in here. I updated all of this
Okay, so
too.
this is actually current.
Yes, this is the
Okay.
current law.
So the reasoning for the limit of 3 is, at least my understanding is that we kind of let exempt settings or nonprofits have more because they're more likely to have a greater need and not be able to pay for, enough supervisors. But I think that the intent is more that the for-profit agencies should have, more oversight. So the way that I look at it is that the limit of 3 is a little bit more, it's, whether it's a other for-profit or a corporation or a private practice, like, I think the same, in my mind, the same logic of the limiting applies.
Yeah.
So the 1-to-3 ratio across the board for everybody, no matter what setting.
Except unless they're exempt. They're exempt,
and-
we kind of make an exception because,
Right.
yeah, there's financial issues with hiring the supervisors, but a for-profit company, if you follow the reasoning that we think that's in the law for it,
I think 1-to-3 is good.
Yeah. No,
What-
I agree.
I mean, what about settings that actually hire or have positions that are clinical supervisors and their primary role is just to supervise, and they don't have any direct service requirements? There are agencies that have that, and I'm wondering what
How
impact.
many do they supervise now?
I mean, that would depend on the agency, but there are agencies like, I know Seneca Center has positions where they're clinical supervisors, and that's their job. They don't do direct service. They don't necessarily are a part of the management team. They're clinical supervisors, and their role is to oversee trainees and associates, and they may do other activities. So I'm just wondering what sort of impact it would have on agencies that carve out positions for clinical supervision solely.
Good question.
So right now, the rule, I know, at least for the LCSW, is 1-to-8, without, consideration of the setting.
Oh, for group supervision.
Group supervision.
Oh, group supervision.
Group
No.
supervision. Oh, no, I'm
Yeah,
sorry, I
group's
take it back.
different.
Erase.
But this
Delete.
is direct,
This is direct, yes.
direct supervision, 1-to-3.
People who filled out the form and sent it to the
Right.
board and
Yes,
says,
yes,
these
yes.
3 are.
Right.
Okay.
Yeah. And I think that's consistent now. I think we just, in AB 93, there was a cap of 15. We removed the cap.
15, and actually, this is kind of going on a tangent. If we're concerned about the 1-to-3 being a little bit limited, I think that we could discuss bumping it up to 1-to-4. And the reason that I say that is because now we're allowed to do triadic supervision. And when I was doing the implementation for AB 93, I kind of had this thought where if you're doing triadic supervision, it doesn't really help you if you can still only have 3 supervisees. So this
That would
might be a place to bump it up to 4, so that at least if you're doing triadic, you can do the 2-on-2 each time, and it frees up a little bit more supervisors. So that might be the place that you could, this kind of compromise, or not.
Good thought.
Throw that out there.
The other thing I wanted to mention, I think where you come into a difference with the private practice and professional corporation is, and the difference with a for-profit is the for-profit might hire somebody solely to supervise, but in a private practice, the law requires people to be actively engaged in performing services there. So that's maybe why there's the limit. So I can see both sides of it.
Which isn't for the but shouldn't so if you have a private practice and you're requiring them to be actively engaged in services, wouldn't you want the same for a different corporation?
Good question.
What's the difference? Wouldn't you want them actively involved in the company?
They technically would be because they're providing clinical supervision within the structure and the framework of that agency. And so their role is to provide, they don't necessarily need that position to be generating funds or money for the agency. Their job is to develop the workforce. And so they support the clinical development of the workforce. Whereas a private practice, you have to supervise clients and you're also required to bring in money for the agency because we're in private practice to make money. And so there's that.
So Jonathan, are you okay with the 1 to 3, or are you thinking that you would like to see it revised?
I mean, I like the 1 to 4, or just looking at how we could bump that up. I mean, 3 does seem a little restrictive, but looking at another number I'd be interested in that.
Betty, go
I
ahead.
I would be concerned in the larger entities that this could have some unintended consequences. If other for-profit entities have currently structured their supervision to hire someone that exclusively does supervision, or I don't know, I just don't want to see us impacting entities that are providing services that are going to be harmed unintentionally by us implementing this. And that would be, I don't know enough about what the current practice is in those other for-profit settings. I understand in private practice, it makes absolutely sense. And I don't have a slightest heartburn over continuing to do that. But I suspect that if we change the language to say this also applies to other for-profit, that we're going to have unintended consequences for a lot of agencies out there that have developed a different model or a different plan. And I mean, it could in fact harm consumers by really limiting access to service if they have to completely redo their model of supervision.
Good thought. So Christy, is the language, the way it's structured now, it would allow other for-profit settings to have more than 3 supervisees?
And they
So
can.
we, if we like that model, then we just don't do anything?
Right.
Okay.
Maybe changing to 4, 1 to 4, right?
That would be for,
I think that
For
would be a
private practice.
I think that's a proactive solution, because I think once AB 93 goes into effect, we're going to start getting the calls of, well, I'm doing triadic so I can have one more in the session, but you're only letting me do 3. I just think 4 makes more sense.
For which setting? Oh.
Private practice.
Yeah. Okay.
Would we be able to revise it in this?
I think this is a good, if we're going to
The
do it,
vehicle?
this would be the vehicle to do
Okay.
it in.
All righty.
That's fine, yeah. Okay. Public comments? Okay, so you're okay for us, for the language, being written right now. Good.
great.
Okay.
Okay, just a couple more to go through here. Okay, so you have a registrant, they have 6 years before your registration runs out, and then they have to get a new number. So once you've been registered for 6 years, you cannot work in a private practice setting. So the purpose for that is to prohibit individuals from providing services indefinitely as a registrant in private practice, and not necessarily that it's a consumer protection issue, but it maintains openings for others to gain experience in a private practice, because otherwise then, you've got the limit and those could fill up and nobody else gets that experience. So I also wanted to mention that the 6-year limit for registrants in private practice was discussed by the Policy and Advocacy Committee back in June 2016, and the committee took no action on the issue. Of course, we didn't talk about the limit in context of other for-profit settings. So basically the question is it acceptable to continue allowing individuals to provide services indefinitely as a registrant in other for-profit settings?
Kind of like have a little deja vu moment. Oh my goodness. So this is really interesting, because I think I remember, we talked about, the register, how long the validity, of the, I mean, what really is the purpose, for that 6 years, and what would be, the possible consequences, if a person stay being, a registrant, get 2 consecutive numbers and continuing being a registrant. So Yeah, so right now, so right now, the recommendation is that they can or cannot.
They can.
They can stay on,
Mhm.
yeah. And so I guess that, my struggle is probably, like I say, that deja vu moment. But I think, if they are earning, actively being supervised, I don't see any reason why not.
And I'll just say that I feel the same about this one as I did about my last comment, that I think it would have tremendous unintended consequences if we changed the rule.
Also, just to reiterate to kind of piggyback on that, we do with the exam restructure after 6 years when they have to get a new registration number, they are required to have passed the law and ethics exam. So there is that kind of assurance that they're at least able to pass that exam when they get a new number.
Yes, yes. Any other comments, Jonathan?
No, I was just
You
going to
good?
say, I would agree with Betty. I think this is something that's better left for the agencies to sort of determine whether or not they want employees who are eternal registrants.
Yes.
Versus getting a license, because I know, for example, San Francisco County, you're expected, once you get hired, if you're a registrant, you have to get your license within a specific time frame or you lose your job, so I think that's.
Actually, being an intern or the registrants are way more expensive, for the agency, than hiring, because of the amount of the supervision that they're providing. They might be paying a higher salary because they're licensed, and yet, all the other support and supervision they get is way more expensive. So any agency want to just, keep hiring intern, or keep that intern for, or the associates, for so long without the license. It's kind of, I think it's a different questions about the quality of the services. But it's beyond the scope here right now. But so I think you got the answer that
Yes,
it's
that is
yeah, we're
okay.
good. Number 10.
Okay, to continue. So this is our last one. This has to do with the LPCC profession, and to get licensed, you have to have 150 hours of experience in a community mental health setting. And that is defined as a setting where clients routinely receive psychopharmacological interventions in conjunction with psychotherapy, and the clients receive coordinated care that includes a collaboration of mental health providers. The definition excludes private practices, professional corporations, and corporations of unlicensed individuals from the definition. So the background with this law is it was included in the legislation that established LPCC licensure in order to address some opposition to the bill. We think that these types of settings were excluded from the definition because they're less likely to offer coordinated or collaborative care. So it seems to me that the types of settings were carefully considered when this law was written, but we might want to discuss whether the other for-profits are likely to meet this definition. Are they likely to offer psychopharmacological interventions in conjunction with psychotherapy? Are they likely to offer coordinated or collaborative care? It's probably, it may not be consistent, but it may not be consistent in these other settings that are allowed either, so I'm not sure.
Can I ask a clarifying question? Would an example of a for-profit be like Kaiser? I mean, would that be an example?
Kaiser,
Like
Kaiser
if
is
someone
a
works at Kaiser Permanente?
Kaiser's a weird, it's partially nonprofit, partially for-profit. Kaiser's like 3 different things. And I can't remember which parts of it are for-profit or nonprofit.
So this is like the 150 hours of hospital experience, right?
Yeah, I guess you could say hospital,
Yeah.
but I would think Kaiser would
Yeah.
fall under this.
So, so again, if we leave it as proposed, we're saying it's okay. Or are we trying to exclude it?
Just should we exclude it is the
Should we?
question. I haven't, I know there's already some confusion about what types of settings are acceptable. And I know that staff gets that question a lot, but I don't know that they're necessarily problematic, those settings, and I personally don't think they need to be excluded.
Yeah. Betty?
So just, Christy, wouldn't it already specify that they have to provide the coordinated care, including the
good point.
psychopharmacological?
Right, that's a good
So
point.
if it's already saying that, doesn't that suggest that the other for-profit setting would have to would have to satisfy that requirement. And if they do, then I don't know why we would want to exclude them.
There you go.
I agree.
Also, the definition prohibits corporations, so some of the other nonprofit are already going to be excluded by this. So I think if we left it as is, it would still be okay.
I think so.
Should be. Kenneth?
Hi, Kenneth sorry, I'm losing my voice altogether. Kenneth Edwards, Calpic. We agree that the other sites should not be excluded because we have seen and had some complaints from members that in the community health setting, because of some of the other rules with an issue that we're working with separately, that they're not able to work in community health settings because of how they bill and because of Department of Healthcare Services. So this would be a good way to help them be able to find other sites and be able to do that. So thank you.
All right. Thank you. Okay.
All right.
Any other public comments about that? Okay. So I think we're pretty consistent.
Yes,
Yep.
thank you. You guys did a good job working your way through that, so.
No, you did a very good job in finding, these little areas to address. So, yeah, make it even more perfect. And Jenny, you have a comment, huh? Oh, okay.
So on
Well,
this item, then, we have some work to do for the language, and then we need to bring it back.
Yes, exactly. So what, and I have one more very minor topic to talk about, but yes, so I'll be bringing back proposed language on what we just discussed. So
Do
how
we want to
it's
bring
gonna
it to
look.
board, or do we want to go through P&A one more time?
Yeah, let's do P&A one more
Let's
time
do
on that.
P&A because, yeah, we want to.
Yeah, and I want to talk about how we might, Roseanne and I have talked kind of with Kim a little bit about how we might want to approach taking this pieces of this forward that are ready. But I do have one other little thing, and that was in attachment E, to clarify. When I was looking at the student issue, I was reading the section on social work students. And while in the read of it, it appears to exclude private practices, I think it just needs to be made more explicit. So attachment E would take out this piece about working in a recognized training program, because that's the piece I think might give the impression that other types of settings are acceptable. And I couldn't find anything that said there are some sort of recognized training programs out there. Who does the recognizing? It's not CSWE. It's not, there's not like, I talked to Jan Lee a little bit, there's not, scholarship or stipend programs that are some sort of training program. So this is just tightening up, they shall not perform clinical social work in a private practice. So that's the deal here. So if we're okay with that.
Yeah. Okay. Yeah, sounds good. Jenny?
Janley Wong, NASW, wanted to go back to attachment C. And I guess it's number D. It defines what licensed mental health professionals, who they are, and it includes registered associates. So I think I understand you're just trying to keep them all in one paragraph, but I feel like it could be a little confusing to call registered associates licensed, and maybe some work on that paragraph to make sure there's no confusion that, some associate might come forward and say, well, this paragraph defines me as licensed.
Would a meaningful adjustment be just putting the word or?
Or
Because-
registered.
Or
That might
registered,
work, yeah.
and then just run it.
But
let-
play with it and see if you can make it clear, very clear, that we're talking about two different things here.
Okay, thank you.
Very good. Maybe talking about like supervised by blah, blah, maybe that would be a little bit clearer. I don't know. Because I see Jenny's point, you don't mix, the license and the license track, together. So maybe just kind of
Yeah.
even like a apostrophe or a comma, to
Yeah, there's
separate the
some way to
categories.
kind of tease that out,
Yeah.
yes. Okay.
Yes.
Does the state use the LAPA language, licensed
Well,
practitioners
this
of the
is who
healing
afforded
arts, or does it,
corporations, I don't think.
or is that just like on a local level? Because in San Francisco,
This
they-
has to do
if you're a
with-
LAPA, that could be a licensed person or a registered intern, then you have rights to do certain things. And so I didn't know if on the state level they use that
I
language.
haven't seen that. I have,
Licensed
That
practitioners
in
in
the
March.
BMP codes anywhere. Usually you say mental health professionals, licensed
Or
professionals,
other
licensed mental health
licensures.
professionals. So,
Okay.
I think that's more like
You
a
need to clarify what
medical
the
language, because we use the same thing too. Yeah. So, but I think that also, if you bring it up, that's also very confusing because everybody's licensed, under, in their view, whether you're licensed track or not, registering or not, so. Because that was more for the distinguish, between the case managers and all the other stuff, yeah. So, anyway. Okay, so we're gonna, so Christy and Roseanne, you guys are gonna work on it and bring it back at the next, or bring it back to the PMA meeting, to relook at it again.
That's kind of what we wanted to talk about.
Okay.
Because with the way that the legislative cycle is looking for this year, there's a couple of different options that we can pursue, because it looks like some of this language is ready, and then we have to go through and do some of the things we discussed today, require amendments in other parts of the law. So what we were kind of thinking is that if we wanted to move, if we were okay with, it's attachment A.
Attachment A, yeah.
And B.
Exempt setting.
A and
language.
C. We're thinking that we could try to pursue a bill proposal this year, but that would require finding a bill in January, February. And obviously the language at this point wouldn't be ready for the full language if it's a slam dunk. Wouldn't be approved till the February or March board meeting for the other things. So we were thinking we could start pursuing it as a bill proposal in January if the board approves attachments A and C in November. And then if the board approves it in March, the rest of the language in March, then we could amend that into the bill. Or if not, and we could decide at that time whether we want it to be a 2-year bill or we want to move forward with part of it, or kind of how it goes. But at least it gives us the option to either run the bill this year or run it as a 2-year bill.
Right.
So that's kind of our thought process on that.
So then we need a motion.
so we'd need, yeah.
And I would wrap in attachment E, I think could go with that too. E. A, C, and E.
So I move that we direct staff to make any discussed changes and any non-substantive changes, and recommend moving parts A, C, and E to the full board as regulatory proposal.
I'll second it.
Oh, well.
Legislative proposal.
As a legislative proposal, and then continuing to work on the rest of the draft language.
And continuing to work on the draft language.
I second that. So any other public comments, discussion? Okay, we're ready to vote.
Christina Wong,
Yes.
Betty Conley,
Yes.
Jonathan Maddox,
Yes.
motion carries.
Thank you so much. This is very thorough discussion, yes, and what's that? Not yet, we have, some reports, we have some updates. And then we're done. Yeah, and then we're done. So we're gonna do the updates first, and then. Oh, yeah, the updates shouldn't take too long. This is the real update.
It looks worse than it is.
I know, but it's really not. So Roseanne, go ahead, take it away.
All right, with the legislative updates, though, I am going to point out a couple of things that I think are important to point out, because we did have, all bills have now either been signed or vetoed for the year. So the good news is all 3 of the board sponsors' proposals were signed by the governor. We have AB 93, which is a huge bill. It's about 75 to 80 pages printed out. So we're right now going through that and trying to figure out implementation. So I know the associations are waiting to kind of get some direction to us on how we're going to move forward with that bill and some other bills. So stay tuned, we're working on it. It's going to be a lot of website form updates, things like that. And then in terms of other bills, AB 456 was the bill that's allowing associate social workers to have the 90-day rule. That will become effective on January 1, 19. Anybody that's applying as an ASW can have the 90-day rule. However, for people it kind of becomes effective in 2 parts. Anybody that completes their degree program on or after January 1, 2020 will have to, in order to use the 90-day rule for all 3 license types, will have to be able to show proof upon licensure that their employer fingerprinted them for the 90-day rule to count. AB 1436 was also signed by the governor. That becomes effective January 1, 2021. All applicants for licensure and current licensees upon renewal will need to show or attest to the fact that they've taken 6 hours of coursework or have experience in suicide risk assessment and intervention. So we're going to be doing some outreach on that. AB 2296 is another significant bill that was signed that was sponsored by CalPIC. It does a few key things. It allows LPCCs now to be child custody evaluators. It deletes the 0.5 quarter unit core content requirements off of each of the core content requirements, and then it allows for a limited amount of time certain in-state applicants to remediate the assessment and diagnosis core content areas. So I know that I've been in contact with CalPIC. We're working on some outreach materials, so hopefully we'll have that out shortly. And then AB 2138 was another bill that was signed by the governor. It makes pretty significant amendments to the board's enforcement process, including limits on when a board can deny a license based on convictions or other acts. So we're working with the department. All the boards are going to be doing regulations. So we'll be working pretty soon on bringing some discussion about the regulations to the board.
Correct. And as a result, there's a very aggressive timeline because this becomes effective July 1, 2020, and the reg process is not an expeditious process. So I'd like the committee members to consider their calendars because I think we're going to need to add a couple extra meetings specific just to discuss the regs for 2138. Wanted to look at, and I'll throw out some dates later, I guess, but I'm looking at potential dates in January, March, and perhaps maybe December of this year. So
that would change. So that would change, you know, how the enforcement units operation and our own legislation.
it does.
Regulations.
It's regs. It's totally, it's a regulation process. We have a meeting with Sabina next week to start diving into that piece. Roseanne's done a really good job of identifying some areas already, and we need to sit down and see what's going to be monumental in terms of a reg package versus what are going to be the easy, like an omnibus bill. You can do that through the reg process too. So we might have a couple different regulations running at the same time.
Yeah.
So. But in order for us, right now, the way the department has mapped out the timeline, in order for us to meet our July 1, 2020 date, we need to have approved language to legal by May.
They actually said April, but it's not going to be April. It's going to be May.
It's going to be May.
Yeah, because we don't meet in April. The board doesn't.
And then at that point, then they have 90 days. They're giving themselves 90 days to approve the language, and then and that's that pre-review process.
And so you talk about the rulemaking process.
Oh, yeah.
So that's what I was about to say, you know, because knowing that, you know, some of the packet has been, you know, taking longer than it should. And so if it's already, I mean, you know, the time, you know, we only have like 14 months to work
right
around. Yes, 14 months. So I would really encourage the staff to work with DCA.
It will
and
not
make
be
sure.
us that falls short on this, I
Yeah,
promise.
I know, yeah. So just a good reminder.
It will not be us.
Not as, you know, like the other ones.
Kind of over my dead body thing. It's not going to be us.
Okay, great.
Just finally, I wanted to point one more thing out because it was kind of a surprise to me. But SB 906, which was the Peer Support Specialist Certification Bill, the board had a supportive amended position on that. That bill made it through the legislature, but was actually vetoed by the governor. So just wanted to throw that out there. So
Yeah.
probably.
Yeah, I'm sure.
A lot of other states have it. So
Yes, yes. Well, I'm sure that it's about the timing. So, you know, if this is for the good cause, and, you know, we'll come back. So thanks, Roseanne, for the update. And this is kind of like a little, guessing game. It's like, oh, what is going to be signed by the governor? And bam, this is like, okay, this is the result. So thank you so much. So the next one is the status of board rulemaking proposal, and it's Christy.
Yes, so we have several regulation packages pending. The first one has to do with the enforcement process. This was approved by the board in February 2017 and began the DCA initial review in July 2017. And Roseanne tells me that it's at agency, which means it's nearing the end of the DCA review process.
Yeah, I think Mr. Markov told us at the board meeting that it had gone to agency. So it's hit the 30-day mark, and so I put in a request with Mr. Markov yesterday to inquire about the status.
Very good.
Thank you so much.
Sure.
I think, what's that?
Oh, I have a few more.
Oh, that's right, sorry.
Okay, that's okay. The
Lunchtime.
next reg package that was, this has to do with obtaining contact information from our licensees, dealing with laying out our application requirements and setting requirements when there's a supervisor that's been incapacitated. So that was approved by the board in March 2017, began the DCA initial review process in August 2017. And DCA did get us some feedback, but we had to stop because what has come out of the License Portability Committee, that is going to change application requirements, and there's some language in there that we'll have to look back at. So right now, we're trying to figure out, do we pull the other pieces of this, like the incapacitated supervisors, and move forward with that? So we're trying to figure out what to do with this reg package. So you'll be hearing back on that. The next reg package deals with examination rescoring, application abandonment, and subsequent registration fees. This was approved by the board in November 2017, began the DCA initial review in April 2018. And I just got some feedback from DCA, some additional feedback, because there's a back and forth. So, so that's, I feel like that's getting close to going to agency. I'm sorry. No, this one is at agency. My apologies. This one is at agency, and I got feedback from agency is what happened. So, and that I need to respond to. There is one that's not listed here, and it has to do with supervision regulations that now that AB 93 is passed, we'll get that going as well. And that deals with taking those supervision regs a step further and registering supervisors and supervisor self-assessments and specifying training requirements, things like that. So we'll get that going shortly.
Any other discussion? The update regarding Christie's update? Okay, we're good. So the next item is the public comments for items not on the agenda. Okay, and the next one, suggestions for future agenda items. Board members, public? Okay, so looks like it's time to adjourn. The time now is 12:47, and we are adjourned for the Policy and Advocacy Committee meeting today. Thank you so much.